Yeah, it's fine. Got the one. So the password is.
They are, it's very yourself. See, one of us hanging around my house. I lived out there. Trying to cover, it was obviously sick. I just knew, but, you know, I was trying to get off and die somewhere. Brought it into the house.
Thinking we went to one, that's my fault.
Whatever company. It was already set up.
Very nice.
I'll find it.
They all left your bread, you're on the wrong one.
Right. No, it's time, yes. Yeah, it's time. At one point it was.
I think Sharon started to do this one.
Okay.
I keep trying to delete it, but I don't think you'll delete it.
You're about this big.
Found that they're super furry. Well, there's somebody else who said.
So.
I don't know, just get rid of it. For Robin, I'm gonna meet with her. And I was gonna tell them how to use it. Here's all the red sign. She needs to learn she's the women, we don't have this. Joyce gives it out. So, United has all the notes on it. This is what was on the office.
Oh, okay, that's getting me. Yeah, November.
Yeah,
That's what we're using.
for this. I don't think I should use the other one. I don't know, I got that it's him that I missed. The other day, I had over 700 text messages and call out to this building. That's great. This type is about right, lose my hair. Yes. Funny emails talking about no spam.
Unless you know.
Exactly.
So I will have to eat something.
We are going to start today's Ohio Election Commission meeting. We'll start with the roll call by Executive Director.
Mr. Caraway, present. Mr. Delisle, present. Ms. Hagan,
Present.
Mr. Knight, here, Mr. Kircher. Here, Kircher, excuse me. I know we got a friend who's the Kircher, or an old buddy, I apologize. Ms. Davis,
Here.
Chair Tavares,
Here.
all members are present.
Thank you very much. And now we'll go to the minutes. Hopefully everyone has read the minutes. Are there any changes? If not, approval. Motion. Thank you very much. Is there a second? Thank you. It's been moved and properly second. All in favor, say aye. Aye. Abstain. Opposed? Right. Thank you very much. That is a vote of 6-0. And Mr. Chair, for the next case, I am going to recuse myself and ask that Ms. Hagan take over as the chair.
Chair, members of the commission, this is item number 2 on the agenda, case 2024 G-008, Parkland versus Weinstein. You've heard that Ms. Tavares, Chair Tavares is recusing herself from consideration in this matter. Mr. Pilkey is present and we have a full contingent. Madam Chair, you can see the complaint asserts the respondent made an improper contribution to an entity that was neither a PAC nor a proper 501c organization. We have received responses, we've received motions, and memorandum, legal memorandum, all that has been provided to everybody for their consideration. Mr. Hartman is here on behalf of the complainant. Mr. McTighe is here on behalf of the respondent. If the commission would like to hear from them further, we can have Mr. Hartman to make his presentation.
Thank you, Mr. Richard. Does anybody in the commission care to hear from the legal or respond on the case? Very good. And since we have both attorneys representing the case, I don't believe they need to be sworn. Is that accurate? Okay, very good. Any further? Would we leave?
Mr. Hartman.
Thank you, Madam Chair. And just to clarify for the record, we're not being sworn, but we are still offering factual testimony and evidence and all that. I would point out, I think the Supreme Court actually recommends that oaths do be given even to attorneys, but I'll let you guys figure that out on another day. But I just want to make sure we are proceeding quasi judicially.
We can start right now.
Okay,
All right.
Do you swear from the tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
This is a relatively straightforward matter for the commission. And at the end of the day, the ultimate question is when the Weinstein campaign made a contribution to an organization called Clock Tower Collaborative, was that a legitimate expenditure? Revised Code 3517.08G provides to whom such contributions or expenditures of campaign funds may be made. In this case, the ultimate question is, did it make the is the contribution to Clock Tower Collaborative to an organization that is exempt from federal taxation under 501A or 501C of the Internal Revenue Code? Got various memorandum. Initially, the respondents simply said, hey, we're a nonprofit corporation. Here it is. We've got a taxpayer ID. We're tax exempt, as my memorandum in response clearly indicates. And as the complainant acknowledges in their response, nonprofit status does not equal tax exempt. Nonprofit status is a question of state law. Tax exemption is a question of federal law. And so therefore the question becomes, under federal law, are they tax exempt? In response to our memorandum, Mr. McTighe, on behalf of the respondents, tendered various documents saying, hey, we don't even have to file an application to get approval of our tax exempt status. And I'll agree with that. He provides the publication 557 attached to it. But if you look at that publication on page 48 of that publication, I think it's page 7 of the excerpts that he provided in his response. It's on this page with a heading that says other section 501c organizations. In the first column there, and Mr. McTighe points to that section that says optional application for recognition of exemption. So if you want to get certified by the IRS, you need to submit that form. But go up to the paragraph before that. Paragraph before that says notice requirements. Every new section 501c4 organization must use form 8976 to provide notice to the IRS. The organization must file form 8976 within 60 days of establishment. Providing that form is not a determination of its recognition. So here, and clearly we have the respondents who have apparently good communication because they're getting these documents from Clock Tower Collaborative. My question would be, where is the form 8976 that Clock Tower Collaborative filed to notify the IRS that it was claiming status as a 501c4 organization? They don't provide it. I would submit to you, it never was provided. They do not comply with federal law. The law, and I would reference, I can get copies here. This is the notice for this rule that we required, and this was from 2016 when this requirement put in, it's in the volume 81 of the Federal Register at page 45008. And it talks about this form, this requirement, and it basically sets forth that 501c4 organizations must notify the IRS within 60 days of formation. And it says such an organization is exempt if it actually satisfies the requirements applicable to such status. We don't have any evidence in that regard. All we do right now is got basically saying, oh, they don't have to do anything. But the organization to which the Weinstein campaign made contributions, as far as we can tell, and there's no evidence, has not filed required forms with the IRS to be a 501c4. They had to notify them at a minimum. They wanted formal recognition because what they got to do is they got to go through and expose what their operations are. The tax exempt section of the IRS looks at it and figures out, okay, do you meet the criteria? We'll give you recognition. That's optional. But what is required is that form 8976. And if the Weinstein campaign is able to get all these various forms, private communications to the organization, where's that form 8976? It's not there. They never filed it. Simply saying, oh, we're a 501c4 does not make you one. The contribution was clearly not to one. And the statute isn't one to an organization that claims to be a 501c4. It's to one that is a 501c4. Contribution was illegal. Thank you.
Do any members of the board have questions for the plaintiff, Mr. Hartman? Oh, I apologize.
I do, but I can, I'd like to hear from.
Sure. Welcome. Would you also like to be sworn to be consistent with? Thank you so much.
You swear from the tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Don McTighe on behalf of the respondents, and I have several problems with this complaint. The first problem is that there are two claims made. One is that there's a violation of Revised Code Section 3599.04. That is a statute outside of the jurisdiction of the Elections Commission. It's the so-called corrupt practices statute. I already discussed that with Mr. Richter. I believe he's in agreement on that. The other allegation is that there's a violation of 3517.08, I believe Division G, which is about making donations to nonprofit organizations. What is important to appreciate about this statute is that it is not a prohibitory statute. There is no prohibitory language in this statute. It doesn't say you can only make contributions to the following. It doesn't say it's a violation if you make it to an organization that is not tax exempt. This is one of those permissive statutes. It is in contrast to the actual prohibitions that are in 3517.13, which is, as you are familiar with, is a long alphabetical list of divisions about everything that is prohibited that relates back to other parts of Chapter 3517. So basically, the only allegation here is that 08 was violated, but 08 is, as I said, a permissive statute. It's not, it's also, again, by contrast with other campaign finance statutes like 3517.10 and 3517.11, which impose duties. Shall file report, shall list contributions, shall list expenditures. Those are mandatory duties that are imposed. So if you don't comply with that, you could be in violation of that section because it imposes a mandatory duty. Also, go to 13 and it'll say anybody who fails to do that violates this division of 13. Okay, so what we have here is, I think, an improper pleading of the revised code section that is really at issue here, because again, this is a permissive statute. the third thing is that this fails to comply, the complaint fails to comply with the commission's administrative rule on what's required for complaints in order to invoke the commission's jurisdiction. Specifically, Rule 3517-1-02, paragraph A, paragraph 1, paragraph F, which basically says that, not basically, says that the complaint shall clearly set forth sufficient facts supported by affidavits, exhibits, and other documents to constitute a prima facie violation of Ohio election laws over which the commission has jurisdiction. So what we have in the affidavit here, there's only basically two facts alleged. One, friends of Casey Weinstein made a $250 contribution or donation to the Clock Tower Collaborative. And that's fact one, not in dispute. Okay. Fact two, Barbara Hartman, the complainant, went on the IRS website, and there's a portal for searching filings by nonprofit organizations. She searched the name Clock Tower and various versions of that, various counties, could not find anything. So in fact, that's most of what the complaint is about her search efforts through the IRS website. And so that's the second fact. Yes, she searched, she did not find. I agree. It's not there. Okay. Of course, you're going to learn why it's not there. And it's not required to be there at this point in time. So these two facts, which are really the only two facts alleged, do not constitute a prima facie violation of the statute, because it makes from these two facts, the complainant then jumps to the erroneous legal conclusion that because this organization is not on the website, it's not tax exempt. That is just plain and simple wrong. You can be tax exempt without being on the IRS website. So that is a misstatement of law on the legal conclusion drawn by the complainant. So this is it's crucial at this point that I think we get into exactly what the requirements are for 501c4 organizations. The commission is essentially being asked to look at federal law and apply federal law. Okay. An area, by the way, outside your jurisdiction, probably, but or maybe this is not the appropriate forum for making determinations on whether a nonprofit organization actually is tax exempt under Internal Revenue Code section 501c4. However, that is where we are at the moment. So and just so we're clear about the C4 designation, Clock Tower Collaborative claims to be a 501c4 organization, as not in this case because they were not named as a party. Okay. But in another case that is pending before the commission, in which Mr. Hartman represents the complainant, the allegation, represented. I'm getting confused between two different cases. There were two cases, both heard in January. One that was dismissed. In the case that was dismissed in January, which was Barnes versus Getz et al., it was alleged that Clock Tower Collaborative is a 501c4 organization. It's right in the sworn complaint. Again, Clock Tower, though, wasn't a party in that case, but it was alleged and had to do with alleged campaign finance violations. But be that as it may, you can take judicial notice of that because it's within your records. And now, if we go into the way the federal law works, and I want to preface this by noting, I've been establishing, set up about minimum of 6 501(c)(4) organizations a year for about the past 25 to 30 years. Okay, so I know a thing or two about the federal tax laws as they apply to these organizations. And the IRS allows a C4 entity to essentially self-declare, say, I'm a C4. You don't even have to, you know, you don't have to obtain formal recognition. You don't, they're very clear, the IRS is very clear, you don't have to file the application to be recognized as a C4. You are, if you have just proclaimed yourself a C4, you are a C4. Now, if someone says, oh, you're not a C4, you're not, what would not make you a C4? Well, not following the IRS rules and regulations regarding C4 activity. Now, keep in mind, C4 is a tax exempt category. You get to self-declare that you are a C4 and therefore tax exempt. So essentially it's presumptive, but it can be challenged. Be challenged based on a complaint to the Internal Revenue Service that an organization that is not paying taxes because it claims to be tax exempt as a C4 is not a C4 because its primary purpose is not social welfare. Again, you probably all are familiar with C4 is the designation for so-called social welfare organizations. So that can be sorted out on a complaint to the IRS for an organization that has self-declared. Now, it's true you don't have to apply to be recognized by the officially recognized by the IRS, but you do have to file annually a 990 tax return. All nonprofits file these. It is due on May 15th for the preceding year. In the third case, Clock Tower Collaborative Incorporated with the Secretary of State in 2023. I don't remember the exact date, but regardless, its first 990 is not due until next month. Okay. Hopefully they'll file. I don't represent Clock Tower, but this is one of the reasons that Ms. Hartman could not find anything on the website. Okay? Because you're not required to file the application for recognition as a 501(c)(4). You're not, in Clock Tower's case, it's not required to file its first 990 until next month. And third, I'll get into the Form 8976, which Mr. Hartman brings up. So there was a law passed not too long ago, maybe 10, in my not too long ago, it could be like 10 years ago. Okay, so which basically said, the IRS said, well, we need something that we have all these 501(c) organizations out there claiming to be tax exempt as C4s, but we don't have a list. Okay, so you have to file a notice. That's Form 8976. Now, what's important here is the IRS does not require you to file that in order to be able to claim tax exempt status. This is what's vitally important here. And the counter to what Mr. Hartman has said, if you fail to timely file Form 8976, you face a possible fine. This is spelled out in the IRS publication. There's a per day fine. And in some cases, they don't impose a fine. Sometimes they grant extensions. The bottom line is, though, failure to file it doesn't mean that you're not legitimately a tax exempt organization under Section 501(c)(4). What it means is you have failed to file this notice with the IRS so that they can kind of keep track of you. Okay. But it does not affect your legal standing in any way in terms of whether or not you have to pay tax or don't have to pay tax. Are you tax exempt or not tax exempt? That is an important legal distinction here. And the other thing just to point out is that it's not the organizations that file these Form 8976s are also not viewable on the IRS website. So you don't know who filed one, who didn't file one. Again, a reason that Ms. Hardman perhaps, couldn't find it. Or if you went today, you couldn't find it. The other point that I'll make on, which I think drives home something that I was saying about how you don't have to formally apply for recognition, but you do have to file 990s and still you can be still tax exempt. There is a rule that if you don't file a 990 for 3 consecutive years, then your quote, literally your tax exempt status, which was never formally given to you, is taken away. Okay, because you were tax exempt because you're self-declaring. But after 3 years, if you don't file it, you lose your tax exempt status. Now you can get it back. And one of the ways you have to, in order to get it back, you have to turn around and file the application to be formally recognized because you've been bad by not filing the 990 for 3 years. Okay. Plus, by the way, there's a per day fine as well for filing late 990s. So this is a very involved regulatory scheme by the Internal Revenue Service. This organization is claims to be, at least, I don't know if it is, but it certainly claims to be a 501c4, and that's presumptively valid. You do not see any allegations in this complaint that the organization has failed to comply with the requirements for, what qualifies you as a C4, which is social welfare. Okay, that's not here. If there was going to be a complaint against Casey Weinstein and his committee to say, well, you gave to an organization that's not tax exempt as a C4, you got to set forth some factual allegations to show that they're not tax exempt, other than the fact that you couldn't find anything on the IRS website. And included in the packet, the legal memo, I have a 1-page list from the IRS website as to what is available on the IRS website. And you'll see that applications that after approval are on the website. 8976 is not. 990s are. But again, we haven't gotten to that deadline yet for filing. I would bring up one more time that I don't really believe that this is the proper forum either for determining whether Clock Tower Collaborative is a legitimate 501c4 tax exempt organization. Okay, because that depends on the facts. It depends on the same things that the IRS would have to consider in a complaint to the IRS, that this organization needs to pay taxes. But we don't have that here. We don't have any of those allegations. And really, this is not the appropriate forum, I think, to decide that question of tax law and the actual standing. Because think about this, you would actually be making a decision today. If you found a violation, you'd be making a decision that Clock Tower Collaborative is not a 501c4 organization. Okay, tax exempt organization. That's the decision you would be making. And all due respect, I don't think that this is the proper forum to do that. In addition to the fact that Clock Tower Collaborative is not a main party in this case. The last thing I'll bring up is let's do the hypothetical, okay? If it's not a 501c4 organization, what is it? Well, in the case that is pending before the Elections Commission, by this, and the complaint filed by Mr. Ruffner, in which, again, Mr. Hartman represents the complainant. The allegation there is that Clock Tower Collaborative is a political action committee. Okay. Fine. That's set for, it's coming up for hearing at some point. I'm not involved in that case, but if the allegation by Mr. Hartman's other client that Clock Tower is a PAC, right? If that's true, well, you know what? Friends of Casey Weinstein is allowed to make contributions to PACs. Okay, so if it's a PAC, contribution was allowed. If it's not a PAC, if it is a, you know, a C4, which was alleged in the other case that is no longer pending, then, you know, it's permissible under 08. And for all these reasons, I would respectfully request that you find no violation in this case and be happy to try to answer any questions. Thank you.
Can I do a brief reply, which is normal? To address just a few of the issues that Mr. McTighe raises here. It sounds like he wants to have a full trial today. But I think the commission should appreciate what the procedural posture is. This is a preliminary hearing and simply whether or not there is a prima facie or a probable cause indication that a violation may have occurred. This isn't the venue or the time. It is the venue, but it's not the place by which an full adjudication occurs. Is there sufficient indication that there may have been a violation of the law by an illegal expenditure from the Weinstein Committee? The complaint certainly sets forth that. As I would point out, you know, he wants to start pointing to all of these other complaints that are in this before this commission. One again, and he kind of says there are allegations in those complaints. Some allegations, it is a 501c4, an allegation, it's a PAC. That's not evidence. And it's not proper evidence for this commission to consider today. One, firstly, because it's not evidence, but secondly, it's dealing with other cases. It's not, he said, oh, you can take judicial notice of this. No, you cannot. Judicial notice is about dispositive facts that are undisputed and not subject to dispute. And that you can take, okay, there's allegations, but that's it. And interestingly, there is no evidence actually before the commission today with respect to the complaint that was offered that Clock Tower actually claims or meets the requirements of a 501c4. No, look, they had contact by their responses. They were able to get documents and communicate obviously with officials with Clock Tower Collaborative. My simple question is, where's the affidavit from Clock Tower saying, here's what we do, and therefore we meet the 501c4 requirements? That's noticeably absent. That Ms. McTighe actually said, is it a 501c4 quote? I don't know if it is. It depends on the facts. Those are quotes from him. I'd agree with that. And so what the proper procedure for this commission then is to set it for a full hearing, allow the discovery, allow full facts to come out. Because he doesn't know if it meets the requirements or if it's a 501c4. It depends on the facts. So I'm going to take Mr. McTighe at his words. You know, one final thing, and then I'll conclude, is in terms of this Form 8976. Again, they had the communications with Clock Tower. They were able to get their documents. They didn't get it, Form 8976. If this organization claims to be a 501c4 and it filed the 8976, okay, that'd be kind of indication it clearly does so. But they didn't produce it. I would submit it doesn't exist. But based upon the evidence that is presently before the commission in this case, there's a prima facie indication, there's probable cause that a contribution was made illegally to someone who does not satisfy the authorization under 3517.08. Final thing on that. Ms. McTighe said, oh, that's just a permissive statute. No, it's a statute there to say what is authorized. He basically says everyone can ignore that statute because it doesn't grant anything. No, it grants the authority and imposes the limitation as to where campaign funds can be spent. Under his theory, I guess with this, that, that's only permissive, you can start sending money, campaign monies, just not to for-profit corporations, because there's nothing that prohibits it. No, the General Assembly in 3517.08G clearly said, these are the authorized, here's where you may do your campaign funds, campaign committees, political action committees, and generally speaking, when you're terminating a committee, especially to tax exempt organizations. And the General Assembly put in and incorporated the federal tax law in that section. So it is absolutely appropriate for this commission to apply and to determine federal tax law. State courts do it all the time. When the General Assembly, he wants to say, well, the General Assembly said you can give it to tax exempt organizations, but even though 3517.08 is probably before the commission, you can't enforce that provision. You have to. It is your requirement under state law to enforce the campaign finance provisions. That finance provision specifically references and incorporates federal tax law. Thank you.
Questions for either of these gentlemen?
Madam Chair, if I may, it may be more of a statement, but
Okay.
I recognize that we're not a federal body. And so whether or not the organization did file the Form 8976 isn't necessarily our issue on the federal side. However, the statute that says an expenditure for the purpose of a charitable donation may be made, et cetera. So this Form 8976, we don't know for certain if that has been filed. If it hasn't been filed, then the organization is not a C4. Correct, Mr. Richter, would you?
That is the premise under which I've made my recommendation, yes.
So if the form isn't due to be filed until mid-May, they may have filed it. And if they did file it, then there's, in my opinion, no violation. However, with this being a preliminary review, my statement is, I guess we could hold this over for a full hearing. And if they did file the form, then, we dispense with the case. And if not, we talk about, potential violation. But Madam Chair, that's all.
Commissioner, I appreciate that, and I was thinking along the same lines to a degree. But also I had a question if that is the validating factor or not, because it sounds like they have a 3-year grace period, irregardless of not filing, that they could be in compliance potentially. And so if that's the case, then it looks like a postponed window to May 15th or 2 years beyond May 15th to give them a 3-year period. So that's the only caution I would exude, and maybe these gentlemen care to answer a little more about it.
Just to clarify, you said Form 8976.
Yes.
It's Form 990,
Right.
which is supposed to be required. Form 8976 is supposed to be filed 60 days after your formation, and we have no indication that form was filed.
Okay.
That's the thing.
We also don't have any indication that it was not, because as Mr. McTighe said, there's no publication of it, but yes, I understand.
And they could have easily got it from Clock Tower because they got all these other records from the Clock Tower. Yeah, we're at the preliminary hearing stage, so I just want to make sure you said 8976. I want to make sure you're correct on Form 990.
If I could, just that when we keep saying all these other records that we got, yeah, what we got and submitted attached to the treasurer's affidavit was the taxpayer ID number letter and an automatic generated letter from the Attorney General that goes out to every organization that files with the Ohio Secretary of State as a nonprofit corporation. That's actually something that's publicly available. The 990 or the, so the 990s, yeah, is not due till next month. In terms of the 8976. Yes, I want to emphasize that there is a 60-day deadline. If you miss the deadline, you can have a per day fine until you file it. Again, it says in those letters, because we get them all the time, it says, this is not a determination of whether you're tax exempt. And the reason is because it's just a letter that we're sending you to confirm that you have told us that you believe you are a 501c4. Okay, but we're not making a determination. So it's not a requirement for tax exemption. The only way you lose tax exemption, two ways. One, you don't file 990 for 3 years. And then it's automatically revoked. Your C4 tax exempt, self-declared tax exempt status is revoked. There are ways to get it back, but the other way is on a complaint saying, yeah, this is not really a social welfare organization. Okay, now my suggestion at this point is if you want more information specifically from Clock Tower, that you just continue the preliminary review. I don't think setting the matter for an evidentiary hearing, which will then result in all kinds of discovery and motions and things like that, is necessary. I believe you have enough and you can take, because you can take judicial notice of 2 other cases that were before this commission, where including in one where there was an answer filed by Clock Tower Collaborative. That's the case that's pending, where they say in their answer, we are a 501c4. And in the other case, or actually in both cases, there's a reference in the complaints to a declaration in emails sent by Ms. Howington, where she claims that they are a C4 organization, which is why they don't have to report the names of contributors. Okay, so you can take those are the complaints filed that you're taking judicial notice of. That's why I think that that's enough. But if more is necessary, then I would request that you just continue the preliminary review, and we'll see if we can get an affidavit. Thank you.
But just real briefly, again, you cannot take judicial, it's not dispositive facts. He wants you to take no judicial notice of, as a factual matter, allegations that were made. That's completely misuse of the concept of judicial notice. I would also point out under the commission's statute 3517.155 paragraph B, it provides that if the commission decides that the evidence is insufficient for it to determine whether or not the failure to act or the violation alleged in the complaint has occurred, the commission, by the affirmative vote of 5 members, may request that an investigatory attorney investigate the complaint. And that is actually the process by which the commission should do if it determines the evidence is insufficient for it to determine violation or not. But basically, I think at this stage, the general procedure has been, is there enough indication? It's, probable cause, a prima facie case. Yes. Why are we going to do things different than how we always do things? Thank you.
Thank you, Mr. McTaggart. Mr. Richter, do you have any input based off of your previous?
Couple of comments that I'll make. Presuming they have done nothing to establish themselves as a C4 at this point, with respect to the arguments that have been presented. At the time the contribution was made, then they presumably have not been declared as a C4. And so my recommendation, which is to find a violation, but for good cause, not do anything further. I'm comfortable with that. Alternatively, the next meeting of the commission is May 16th of 2024. We could continue the preliminary review of the matter until that date. And it is one day after the presumed due date for such filing.
Of the 990.
of the 990.
Madam Chair, if I may, Mr. Richter, so if we were to continue the preliminary review, it would not allow the complainant to actually receive discovery, right? So, their
The preliminary review has not been completed yet, and we hold off allowing discovery until the commission sets a hearing, sets a matter for hearing.
So
That's the manner in which the commission is historically operating.
the entity would not necessarily have to file, they would be under no obligation to respond or produce an affidavit, unless it would it be online? Sorry. I'm trying to figure out.
Yeah.
Oh, yeah, it's
Okay.
filed online.
Okay, so, but how would we find out if 8976 was
I
filed?
don't know that we ever would.
That's not-
based on-
you're right.
yeah, that's what requires.
Sorry, I'm getting my forms. So you see what I'm trying to, I don't, the other clock tower would not necessarily have to cooperate with this commission in writing an affidavit or.
There's no obligation on them, no.
Right, we can postpone, we may or may not have more information from May 15th, and so that's really what is the will or desire of the commission at this point.
Just because they missed the 990 deadline doesn't mean they no longer qualify.
Right, they could just take their time on a day-by-day basis.
Or believe that 3 years you mentioned, right, before they would lose their status.
Right, exactly.
So I mean, obviously if they file it by then, it proves it, but it doesn't not prove it if they don't. And would there still be let's say they filed the 990, establish themselves as the appropriate nonprofit status for this. Would that make the contribution proper, even though it was done before they established?
I'm certainly no tax expert, but my initial thought would be yes, because they have then declared that in the year 2023, they were a proper C4 organization.
The mission.
Madam Chair, I make a motion that we,
I'll second that motion.
Was it to dismiss?
yes.
I'll second that.
We can go ahead and take a roll call vote on that.
Okay. Going off the order. Apologize. I just start.
No, I normally go randomly having you as the chair, we get the last vote. Ms. Davis is the mover, we get the second last vote, Mr. Lyle is the second. We get the third last vote, and then we go from there. And so I'll start with Mr. Caraway.
Nay.
Mr. Polkey. Aye. Mr. Kirscher.
Aye.
Mr. Knight.
Aye.
Mr. Lyle.
Aye.
Ms. Davis. Chair. Vice Chair or Chair for this current portion of the meeting.
Aye.
That motion passes 6-1.
If I may, for the record, could I get some clarification from the commission as to the basis for the dismissal? We have a motion made by somebody who never even made a single comment. And I think the commission,
the commission took an action, and so.
but so the commission's not going to explain.
That's their
I mean,
choice, but
The legal law was not violated, that there's not probable cause. I'm just trying to figure out exactly the threshold that was not met. So maybe for future reference, I might be able to do better.
If it's the will of any commission members to speak, you are welcome to, and if not, the decision has been made.
Mr. Hartman, I will respond to you. I just don't believe that there is an opportunity for us to prove or disprove anything based on the timelines. If we can't see a copy of the 8976, if I'm saying the number correctly, and if there's a 3-year time period, I do not believe that it's in the best interest of this commission to hold a case out that long. And I guarantee that anything will be filed. We've discussed that several times. There's no responsibility of Clock Power to do so, and so that is.
I would just point out to the commission that the 3517-155 dictates what you should do if you do not have sufficient evidence to determine whether or not there is or is not a violation. And obviously, you're elected not to pursue that requirement under state law. Thank you.
Thank you.
Very good. Thank you, gentlemen.
Thank you.
I'm going to go ahead and call a 5-minute recess, more or less, in order to
Oh, I love that more glad.
go on the left side.
I'm going more.
Chair, so.
That's great. More.
Yeah, it's not like somebody has you. Somebody picture.
Right, I'm getting it.
Yeah, but they'll be in the person. So.
I don't know. I've already watched all
Are those being like?
these are our scientists, we usually very. But there is. There is, yeah. Everybody, and I think so. I see you're talking to.
No, so it's nice around the pumpkin, one, and sure enough, a comic one, you get your original back. Except for yeah, Bill should. I think he only gave me one.
Yeah,
I'm underrated.
So Chris, I'm the one that made it.
Yeah, those kind of, so it's not. And you can put. And hit you, and then, yeah. Yes. But that it should be on there to see, like, if it was a browser or, whatever. It should be all there. So.
Yeah.
And it's just, and normal getting the receipt for. Okay. Anything over 10.
I didn't just think.
No worries. I figure I'll just attach it anyway.
That's fine.
It's like just sit there.
Sorry. I'll send it on the race.
Yeah, I know. I tell people I got run over by a bus full of cats.
I'm looking for that bus later.
Yeah, I hear you.
My tweets one of my tweets.
I agree. Yeah, yeah.
Do they? You just want to flip it? Yeah. Where do you want that straight?
I mean, that wouldn't be my strategy, but, yeah,
As long as it's fully, it's good.
right.
Oh, well.
Yeah, I'll see you. Talk to you soon.
I know.
It's the part of service side.
Okay.
Nominal.
Yeah.
And I was in every when it's down to include function. That was really good. Like I would film on.
Oh, yeah.
Anybody else here? Here also.
You don't hear it.
And I was already.
In my oval.
My music got up, so.
Okay, so. That one had was the road and I drove.
Stay high full. It's like.
One guy's car and the lift went up. He didn't even know what happened and he's trying to pull over because it was early morning. And the guy behind him runs up to the window. He says, I'm on the window. He says, are you gonna take it? Can I claim it? Yeah, Rex says, claim what? He said, the deer you just hit. Rex, I didn't see what I hit. I think, yeah, you can have it, buddy. I'll bring it into our house. Yeah, that's just.
It was down in the house in
Is he's going to come back.
The flying every day, and then this little car jumped in front of two people, and then it went out of control and hit the wall, and the car exploded everywhere, like pieces everywhere. And the guy driving ended up hitting on his butt in the middle of the lane, just sitting there. And the guy that was filming it is the guy who almost ran over it, but that car was disintegrated.
Oh, yeah.
So with your secret volume awareness, I go on.
Oh, you're fine.
I just want to let you know, so
What time?
it's something to it that.
I do very much.
Yes.
It sounds like the round upstairs.
There's a lot of
There.
emission.
Yeah.
Not your kid, it's like.
It was beautiful.
Whatever was on the thing, you know?
And so, you know, it's very.
Resume our elections commission meeting, and we're gonna go to the case number 2024D-006. It is on page 1. Mr. Executive.
Madam Chair, members of the commission, the complaint asserts that the respondent did not include a proper on electronic campaign piece that was circulated by the candidates campaign committee. The response essentially says that the email communication was the first sent by the vendor for the campaign. The campaign voluntarily confuses the registered name of the committee. There was an error. Once it was recognized, the mistake was corrected and all subsequent campaign materials reflected the proper name of the committee. Based on the complaint and the response, and I'm presuming at least that there's nobody here in the audience for case number 2024D-006, Mylander versus Savage. My recommendation then is to find a violation, but for good cause, not on both the fine or the matter of the prosecution.
Are there any questions of the executive director? If not, do we have a motion?
So
Second.
It's been moved and properly seconded. All in favor? Aye. Opposed? That was carried by a vote of 7-0. The next cases that we're going to take up are on page, I believe it's 3, under the
Reconsiderations. Madam Chair, members of the commission, and the respondent in item number 6, Diane, is it the mute?
the month.
The month, sorry, I apologize
It's a bad
for
last
mispronouncing. We have 2 cases under that heading. And my recommendation is to reconsider the matter, vacate the previous imposition of per diem fines, and instead find that there is good cause present not to impose the fines on the matter of criminal prosecution. The respective arguments of the cases have been presented to you in my reconsideration worksheets. The Springfield Police Department situation involved the death of an officer and the health issues related to the treasurer's, I think it was his father. I'm not looking at my outline right at the moment. And Ms. Demunk is here, and her call to me and looking at the green card on the issue was he changed residences shortly before or shortly after the referral. I think shortly before the referral was filed. The new resident at the house signed the green card, and so we had green card service, but it wasn't her service, and she found out about it after the fact. Requested reconsideration, and so my recommendation is, as I said, is to reconsider and essentially been caused. Ms. Demink, is there anything else you'd like to add to the commission?
No.
Okay. And then the other matter, just kind of a standard reconsideration situation where I think it was the first time for a violation. I can't specifically remember the explanation. It was the previous treasurer resigned without notifying the candidate of Florida Union and campaign finance records. Also during the time of the fourth due to be filed, the candidate was involved in federal criminal fraud, which resulted in the candidate being sentenced to 24 month prison term. My recommendation there is to reconsider the matter, find a violation, vacate the previous finding of the per diem fine, and instead impose a fine of $100. So you have my outlines on the two separate items for reconsideration. I'll be glad to answer any other questions the commission may have. Otherwise, I think they're ready to go forward.
Any questions on any of the 3 cases? The cases again are 2023R-481 and 2023R-499. Those are the 2 cases that we are reconsidering vacating the previous imposition of the per diem fine and instead finding that there is good cause present and not to impose a fine or refer the matter to the prosecution. Is there a motion for those 2 cases?
Madam Chair, just
Yes.
a quick clarification. These reports have been filed there.
Yes.
Okay. You may have said that and I missed it. Madam Chair, I will make that motion.
Okay, it's been properly moved. Is there a second? Been properly moved and seconded. All in favor, say aye.
Aye.
All opposed? That vote is 7-0. The next case, as Mr. Richter outlined his recommendation, is to reconsider the matter, vacate the previous imposition of a per diem fine and instead impose a fine of $100. That's case number 2023R-367. Any questions of the executive director? If not, is there a motion?
Madam Chair, I guess I'll make a motion again.
Thank you very much. Is there a second?
Second.
It's been moved and properly seconded. All in favor, say aye.
Aye.
All opposed? That motion passed by a vote of 7-0. Next, we'll go back.
On page 2, item number 2, The Clark County Republican Party Central Executive Committee at all versus the Republican Party of Ohio. Complaining of service that responded actually improperly and attempting to represent themselves in the Clark County Republican Party, circulated certain materials using the name of the party. We received a response. The respondents assert a variety of arguments to indicate the complaint does not have standing and the party dispute is not a matter of the commission, other issues. Madam Chair, members of the commission, my recommendation on this case is to simply dismiss the matter. I'd be glad to expand on that if the commission wants me to do so. We also have Mr. Collins here on behalf of the complainant and Mr. Harkins here on behalf of the respondents. If the commission would like to hear from them further.
Commission members?
So will we have the opportunity to hear, the council, or you recommending we don't?
That's really your call as it relates to, you know, which, how you would care to proceed. I don't want to see that.
I would like to hear, but certainly understand that, you know, my colleagues.
Thanks so much.
I agree.
I agree.
Okay.
So we will hear from both the complainant and the respondent. And anything else, Mr. Ritter?
Mr. Collins is here on behalf of the complainant. He would know first.
Mr. Pullins?
Thank you, Madam Chair, Commissioners, Director Richter. Good morning. Scott Pullins, attorney, again, appearing on behalf of the Clark County Republican Central Executive Committee. As I said last time I appeared on behalf of this party, these issues are fairly simple, despite the efforts of others to complicate them. Also, as a preliminary matter, I've seen that a number of the respondents who are represented by counsel have signed up to speak. I would object to them speaking at the preliminary hearing. It's a clear violation of rules. Ladies and gentlemen, respondents are disgruntled Republicans from Clark County, Ohio. On June 6, 2022, the Clark County Republican Central Executive Committee reorganized pursuant to state law and elected their officers to 4-year terms. Nonetheless, on June 24, 2022, just 18 days later, respondents first created a Facebook page entitled The Authentic Clark County, Ohio Republican Party. On or around July 1st, 2022, they changed the name of the Facebook page to the Republican Party of Clark County, Ohio. This was over a year before any so-called removal meetings took place and less than a month after the reorganization meeting. Respondents then registered trade names to Ohio Secretary of State and improperly transferred complainant's website address. All these actions and others as alleged in the complaint would lead a reasonable person to believe that their communications and publications are made on behalf of the complainant in violation of state law. Most recently, in a letter sent by respondent Jim Stickford, he admits the allegations and said the following: I know it has been a challenging year. The idea of 2 committees is confusing to say the least. We all have our loyalties. That's understandable. You have not been attending our meetings. I believe the reason is most likely because you prefer to have Laura as your chairman. That is perfectly fine. Mr. Stickford, the respondent, one of the respondents, has admitted in writing that there are 2 groups here. And he says he's perfectly fine with it. Fair enough. And if Mr. Stickford wants to start a Republican club or a conservative club or a conservative PAC or a Patriots League, he is perfectly entitled to do those things. But he is not permitted under state law to call this new group the Republican Party of Clark County, Ohio, or any other confusingly similar name. The bylaws for the Clark County Republican Central Executive Committee do not permit or provide for the removal of its officers, whether by majority vote or a supermajority vote or any other procedure. Because there is no bylaws provision, then Robert's Rules of Order do not permit a removal of this manner. There is no provision in state law concerning the removal of party officers. There was no legal authority for the vice chair to unilaterally call a meeting. Only the chairs may call a meeting, period. These individuals were warned repeatedly More importantly, this commission has no jurisdiction whatsoever to preside over dispute of who is the lawful party chairs in Clark County, Ohio. And we don't ask you to make that decision. We ask you to adjudicate the complaint in front of you. And further, let me say that these disgruntled Republicans could have made legal, lawful choices. These choices could have included filing a lawsuit, as they referenced in the Michigan case they cited, and try to obtain a court order. They have not done so. They could have filed a petition with the Ohio Republican Party. Now they have done this, but the Ohio Republican Party agrees with our position that their petition is not applicable because that portion of state law only applies immediately after a party reorganization meeting. They could attempt to elect new central committee members in the 2026 primary and attempt to elect new officers. Obviously, it's not 2026 yet. And finally, they could change the name of their new group to a club or a PAC or whatever and quit stealing websites, quit filing false designation of treasurers and false campaign finance reports, and quit harassing and confusing people. The Ohio General Assembly passed these laws for these very reasons in this complaint. More importantly, respondents do not deny that they've taken these unlawful actions. In fact, since the filing of this complaint, they have filed even more false designations of treasurer and more false reports. I would ask the commission to find violations of the two statutes cited and issue an appropriate fine. Alternatively, I would ask that the commission set this matter for a full hearing. I'll be happy to answer any questions now or later. Thank you.
Thank you. Any questions? If not, we'll hear from the respondent.
Thank you, Madam Chairman, Commissioners. There are a couple of things that I need to understand. First, there was a motion to strike. I don't know if the commission is going to rule on that or not. It included the certified transcripts of the meetings of the November 2 meetings of both the Central Committee and the Executive Committee. I don't know if
I
that's.
recommend the commission just hear the arguments as it relates to the complaint.
Okay.
Madam Chair, we could have the respondent actually, or the complainant, right? If you could- Yeah, I'm sorry. you're not
I'm the complaint.
Okay, I'm sorry.
Yeah.
If you could just introduce yourself.
Oh, I'm sorry. I'm Dan Harkins. I'm an attorney. I represent all but one of the respondents in this matter.
Okay, thank you.
Mr. Clarkin.
Thank you, Madam Chairman. I'm sorry. There are two other issues before I go on to the argument before the commission. One is on standing and the other is on jurisdiction. I think those are pretty fundamental before we go into the substance of the matter, but I'm happy to go through with the presentation. I just don't want to consume the commission's time but our position, as we stated in our response, was that Mrs. Rosenberger has no standing to bring the complaint for two reasons. One, if you look at the bylaws that she is relying on, the office of chair does not have the authority to bring actions. If an action is going to be brought on behalf of the party and committee, it has to be authorized by that committee. It has not been authorized. And I can say that with confidence because over 60% of the members of both the Central Committee and Executive Committee participated in the November 2 meetings that by a vote of more than 95% removed all the officers. So you would argue that there's a lack of standing for this complaint because it was never authorized by the committee or committees. Second, relying on a case that Mr. Pullins is intimately aware of because he litigated Rosenberger versus Paduchik. Both the Franklin County Common Pleas Court and the Court of Appeals for this district found that Ms. Rosenberger lacked standing and that matters involving party matters are outside the jurisdiction of the courts, and we would also are outside the jurisdiction of this commission. Be that as it may, the presentation that was made by Mr. Pollins is incorrect. The issues involving Laura Rosenberger and then the rest of the officers involve the expectation that the officers would allow members of the committee to exercise their rights, one of which is to call for a special meeting. There were two petitions that were circulated. The first was a petition asking both Mrs. Rosenberger and William Lindsay to resign both as the chair of the executive committee and as the chair of the central committee because of malfeasance. And it's the list of grievances is relatively long. It can be found on Exhibit H if you did bring our response. It's amazing to me what, changing the dates and times of meetings, not telling people that meetings have been changed, that they claim that Robert's Rules of Order is the basis for which all meetings are being run. It's kind of interesting that Mr. Pollins said that there is no provision in Robert's Rules of Order for the removal of any officer, and that's not true. If you look at section 62:16, it clearly provides that a body which is following Robert's Rules of Order has the ability to remove an officer. It states that it's either by a 2/3 vote or a majority vote when there is previous notice, and we would argue to the commission that these two petitions that were circulated did provide that notice. And since the second petition was signed by a majority of the committees before the meetings met, that the for cause was provided. What's interesting is that Mr. Lindsay and Ms. Rosenberger refused to allow committee members to make motions or second them. And then they adopted a process called the second gavel that said that if they were to rap the gavel twice, that they could expel or remove a member from a meeting at their discretion. Again, that's not authorized in Robert's Rules of Order. They also claimed that they could remove anybody as from the membership of the Central Committee. As all of you are aware, members of the Central Committee are elected in the primary election, depending upon the county. It's either on a biennial or quadrennial basis. And all the people that are identified in exhibits, let's see here, exhibits, sorry, E and F and G were duly elected by the people of Clark County for their respective precincts and were duly elected by the Central Committee to the Executive Committee. And Mrs. Rosenberger and Mr. Lindsay feel that they can remove anybody at will. They filed bylaws with the Clark County Board of Elections that were not properly approved by either committee. And then they rest or rely on those bylaws for the purposes of removing members and also to take over the committee without following Robert's Rules of Order. Incredible. As you know, these elected bodies are bodies of deliberation. Every member has the right to be heard. Everybody has the right to be participating. Mrs. Rosenberger and Mr. Lindsay feel otherwise. They feel that as chair that they have the ability to dictate. That is not an American way of doing things. That is not why we elect representatives to the Central Committee. They have been openly hostile to Republican voters and to elected officials. I mean, it's incredible to me that, for example, at the county fair, before they would entertain giving material, that they would quiz people claiming to be Republicans as to whether or not they understood provisions of the United States Constitution, and then would actually try to confirm registration before distributing material. Mrs. Rosenberger insisted on creation of an audit committee. 3 members of the audit committee, 2 of whom indicated that they did not sign reports for the audit committee that Mrs. Rosenberger presented. As these complaints started to continue, by members of both the Central and Executive Committee. Mrs. Rosenberger and Mr. Lindsay objected to the first petition, saying it was not completed or signed by a majority of both committees.
Mr. Harkins, I think on behalf of the commission, I'd ask you to stick to the nature of the
Okay.
complaint and the allegations that have been made in the complaint. I appreciate kind of where you're going, and I think most of the, I'm presuming the commission members read your materials, and so they're familiar with all of that. The recitation at this point, I'm not sure what it really accomplishes.
Thank you. My purpose of going through that is to indicate that you had duly elected members of the committee. The committee membership never changed. The committee members changed the officers. And the basis of this complaint is fallacious. First, the complaint was never authorized by the duly elected committees because over 60% of both committees wanted to get rid of these officers. The bylaws upon which Mrs. Rosenberger relies on does not provide her with the authority to or standing to bring this complaint. They, the officers, Laura Rosenberger, William Lindsay, Carol Godin, Ms. Ward, were all removed. And they were removed properly with notice. And they were, and if they were properly removed with notice in compliance with Robert's Rules of Order, they don't have standing. And the party has never changed. The members of the Central Committee are unchanged. It's not an issue of reorganization with competing members of two different committees. It's the same committee. It's over 60% of the Central Committee voting to get rid of the officers. It's the officers who are refusing to comply with the will of the majority. So we would argue before the commission that the complainant, as presented through Mrs. Rosenberger, lacks standing. Two, that this commission lacks jurisdiction. And three, if we do need to go to an evidentiary hearing, that the evidence that will be presented before the commission will substantiate the proper actions of the respondents. For that reason, I would respectfully request the commission to dismiss the complaint. Thank you. Not happy to respond to any questions anybody may have.
Yeah, Paul, I want to see if there are any questions of either one of,
Madam Chair, could I reply, please?
I want to see if there are any questions from any of the commissioners of either one of the gentlemen who either filed a complaint or is a respondent. Any questions at this?
I think I have a few, Madam Chair, but, so if I may.
Sure. Go right ahead.
The bylaws of the Clark County Republican Party, are they, were they in one of these documents? Because I think they were.
They were filed with our complaint.
That's right.
Our bylaws were filed with our complaint.
So do the bylaws, let me just say this. Mr. Richter and I talked briefly about this particular complaint yesterday. And as someone that has spent, up until last year, I've been on my county central committee for almost 20 years and can't imagine going through what is happening in Clark County. But the basis of my concern here, and part of the reason why I disagree with Mr. Richter's recommendation, is because there are statutory things that a Republican Central and Executive Committee must do. For example, if you have a vacancy in a county commissioner or county office, whatever, there are triggers and responsibilities that Central Committee must carry out. And I'm concerned that in Clark County, if Clark County were to have that situation, that it is so dysfunctional that, both groups claim that they have the legal standing to make that appointment to a county office, for example. And so, and Mr. Richter, I hope I can paraphrase what we talked about yesterday in your recommendation of dispensing with this. The courts haven't wanted to be involved. The Ohio Republican Party doesn't want to be involved. And my question is, then who gets involved? If they are not able to function on their and fulfill their statutory obligations. That's my only concern about dismissing or not hearing more. Does that make Makes sense?
Certainly, but you know, when you, I mean, the commission, as an administrative agency, the commission's jurisdiction is limited to revised code 351708 to 20, essentially, 3359903031. And the basis for my recommendation to just dismiss is, and I appreciate what you're saying about the statute. I'm certainly respectful of the statutes, I think, as anybody, because I believe the commission has a role and responsibility there. But if we make, to me, if we make a finding either violation or no violation in this particular case, we have then aligned ourselves with one side or the other, when the party that really, to me, at least really should be making this determination is the Ohio Republican Party. And they have deferred for making the choice. You know, they have their interpretation of the statute that's at issue. I have my interpretation of the statute. But that statute 351705 and 06 are the primary provisions are not within this commission's jurisdiction. And so I believe it's inappropriate for us to wade into in my opinion, to wade into this to make a decision that could impact the nature of that decision that really should be made, in my opinion, by the Ohio Republican Party, if they can't figure out how to get along with each other. Because it is a party issue. It is the case that was cited. You know, the laws, there are laws in place that identify what parties should be doing, how they go about doing it, et cetera. And in my opinion, the ORP should be stepping in and making some sort of a determination.
If I could reply briefly.
Well, at this point, Mr. Carolan and I are going back and forth.
Yeah.
Let's say you won't,
But, Madam Chair, if I may.
Yes.
Mr. Richter, we talk about 3517 up to 20.
and that's what's here, so I
Right.
understand that.
So 20 specifically identifies political communications and identifying the source of the political communications. So in theory, the Clark County Republican Party or Republicans at Clark County or the Clark County Republican Central and Executive Committee, whatever we want to be today, they could have dual slate cards as an example, but wouldn't one of them be breaking the law? Wouldn't one of them be breaking 3517.20, which requires that, basically imposter, central committee? I mean, part of the reason why that section 20 was added, correct me if I'm wrong,
Right.
was because of these groups popping up throughout the state that said they were the Democrat Party or the Republican Party or whatever. So
But can I just interrupt there? But that's once those dual slate cards have been filed. Before that, we're presuming that somebody could do X or Y.
Sure, understand.
And at least as I have the statute here in front of me, no candidate or entity shall use or cause to be used a false, fictitious, or fraudulent name or address in the making or issuing of a publication or communication included within the provision of this section. There is a group out there presumably now entitled as the Republican Party of Clark County, Ohio, that is an entity of some sort. And if you want to assert that it could be sufficiently confusing, I guess you could do so, but it's a separate and distinct organization. It's not necessarily a false, fictitious, or fraudulent name, as I view this set of circumstances.
Other comments?
Around the clock, Madam Chair. I mean, I think I, at this point, kind of agree with Commissioner Caraway that, I mean, one of the groups has to be offering a fictitious fraudulent view to the public, right, for 3517.20, which falls under our purview. I think we would all prefer not to have to opine here, but I'm challenged understanding why not under 3517.20. Like one of them won't be the central committee and one doesn't. They're both claiming that they are, so one of them has to be fictitious, right?
Does it? Because, you know, one says the Clark County Republican Central Executive Committee, but the other is the Republican Party of Clark County, Ohio. There are, you know, I mean, it's a different name. It is an entity that has been created out there. I mean, it is similar, certainly. Is it false, fictitious, or fraudulent? I mean, and certainly Mr. Pullins and his client is going to assert that it is, and Mr. Harkins is going to say, no, it's not. But it is an entity that exists out there. And it's not it's not like it's also putting out something under the Clark County Republican Party Central Executive Committee.
I guess the difference to me, and again, please tell me why I'm wrong. The difference to me is, you know, I could go and set up the Ernie Knight, Clark County, whatever, and that's an entity. It's all those things that you said, right? Promote that. But that group would not be promoting to be the central committee that has its line of responsibilities and requirements, right? Both of these groups are asserting to the public that they are the county committee that has to, statutorily do X, Y, and Z in an election and beyond, right? So if they're both asserting it, is it the point of this to reduce confusion in the public space? And by definition, this is kind of creating it because they're both claiming to be a very specific type of committee with specific responsibilities.
Madam Chair, if I could reply, I could probably clear some of this
I think
confusion up.
the answer to that is, I guess, to a degree, certainly. But do you know which one is the proper organization?
No, one of them has to be fictitious. One of them has to be, right? Or both, one or both.
Has there been a
There can't be more
sufficient,
than one.
right, don't disagree, has there been a sufficient showing that one as opposed to the other is the proper organization that would be subject to the penalties of this provision?
Because that's the point of a hearing if we proceed to that point, right?
Okay, yeah, we could certainly go to a hearing. But there's where I get back to, is that what this commission is really responsible for doing? Yeah, we're responsible for enforcing 20H, don't get me wrong, I understand that. But, when you've got two parties fighting like this, I just feel like that's an area of the law that this commission is not responsible for. And somebody else needs to be responsible and step up in that regard to give us an indication of, yeah, this is the proper party organization. Otherwise, we're making that, at least in my opinion, we're making that decision by the nature of our finding.
Mr. Kirschner, you had a comment.
Just two questions for our conference. I think that the threshold issues in a lot of these cases become jurisdiction and standing. I know that we spoke about it. I just like to have a real clear understanding as it relates to jurisdiction of this commission over the hearing, and then the standing to bring them. Would you be able to share your thoughts and rationale on that issue? I know that you have in some senses, but I just want to have a clear understanding of your perspective.
I'm not sure exactly what you're asking, but, this commission is responsible for hearing complaints.
As it relates to this particular matter.
We had a complaint filed with us that, as I viewed it, met the
Do you have jurisdiction over the issue, and do the parties have standing before us as threshold questions as okay?
Certainly, we have jurisdiction over the issues, yes. I took it on good faith that when we received a complaint from the Clark County Republican Party Central Executive Committee signed by Laura Rosenberger, nominally the executive director of the executive committee, I believe it was, that we had jurisdiction, that we had a proper party claiming, that there was a violation. And then obviously all the respondents laid out, there. So from a basic standpoint, I believe that this complaint is properly before us, yes. Now, obviously, you heard Mr. Harkins argue, well, they're not the proper party at this point, and here's why, and here's what we did. But at the time when the complaint came in and looking at it, I don't know which, if there's a problem there. Certainly, Ms. Rosenberger was originally appointed as Mr. Fuller pointed out on June 6th of 2022.
What I heard was thought that the proper party, correct me if I'm wrong, to address this matter would be the Ohio Republican Party, which would make me think that your recommendation is based upon the lack of standing in some senses to be before us. So if the recommendation is dismissal, and I apologize if it's being repetitive, can you again state kind of the rationale for that recommendation of a dismissal?
Because again, as I view it, if we make a finding for the complainant in this particular case, who is asserting that the other group is using a false, fictitious or fraudulent name, then as I view things, we have essentially, in our finding, by finding that there's a violation by that group, said that the complainant here is the proper controlling party in Clark County, Ohio. Alternatively, if we find that there is no violation by that group, then we have said that, at least as I view things, then we have said that the complainant in this case was not properly brought, and that the complainant is not the proper party.
Which makes the question from my perspective as it relates to jurisdiction and standing, but be that as it may, that's your recommendation. And would it be then appropriate at this stage, the preliminary hearing stage, for a dismissal?
I believe so, yes.
And last question, why is it you believe the Ohio Republican Party would be the appropriate venue?
Because if you look at 351705 and 06, what it talks about is if there is a breakdown, however you want to phrase it, between fractious groups, those groups, based on reading the statute, those groups are supposed to submit their respective party lists to the county party, or not, I'm sorry, not the county party, the county board of elections, and the county board of elections sends those to the ORP. In this case, the ORP, it could be the ODP as well. And then as the statute holds,
In any event, you believe the more appropriate venue for this would be the Republican Party, the Ohio Republican Party.
so yes, 351705 says if more than one organized group claim to be the rightful county central or executive committee, each such group shall file a list of its officers and members as provided in 351706. And the Board of Elections with which such lists are filed shall certify them to the state central committee on the party concerned. State central committee shall meet within 30 days. Now, I think what to a degree speaking on behalf of the ORP here, but what the ORP is basing its provision here. All changes occurring in the membership of the county central executive committee after such filing shall be reported promptly by the secretary of each board of the committee to the board of the secretary. All changes occurring in the membership of the state central executive committee after such filing shall be reported promptly by the secretary of such committee. But I think what they're saying is that was not done in June of 22 or whenever the reorganization was. And so therefore, this is not properly before them to make that kind of a decision. If I, can interpret what I have been shared with.
I just wanted to understand your kind of recommendation for the dismissal and the rationale. And I don't need any clarification from council personally. I just wanted to understand our council's position.
Madam Chair, I'd ask again to have a reply.
Is there any questions from?
Not my favorite position, but that's the basis for it.
Yeah, it's all right.
Anybody else have any questions before we have the complainant share some additional comments? Go ahead.
Thank you, Madam Chair, Commissioners. First of all, I don't believe the commission has ever taken up an issue of standing. Anyone can file a complaint. I can file a complaint. Anyone in this room can file a complaint. So to argue that they're not a proper party, a standing argument is, I don't think the commission has ever taken up a standing argument. Two, most of Mr. Harkin's arguments are not relevant to this proceeding, not in the least bit. There are 2 complaints before it. The commission has jurisdiction over those complaints. Whether the commission finds a violation or doesn't find a violation will not resolve the issue of who is in control of the party. Court can decide that, or the Ohio Republican Party can decide that, or in 2026, when there's a reorganization meeting, the members can decide it. So either way, that does not decide the issue. If there's a violation found, there's a violation, there may be a fine, there may not be a fine, but there's no order from the commission that says this is the proper central committee or that is the proper executive committee. The commission has 2 allegations in front of it. The respondents have answered. They have not denied the allegations. Mr. Harkins, in his arguments, did not deny the allegations, not once. I mean, to me, when allegations are brought, and they're properly before the commission, and the respondents have answered and have not denied the allegations, counsel has argued and has not denied the allegations. You have an obligation to proceed and find a violation. That's all I have. Thank you.
Thank you.
Excuse me.
I'm sorry,
You just want me to sit down?
I did not.
Comments?
Madam Chair, thank you. The one question that never mind, I think I'm good. Just, this is, you know, I was sitting here thinking about voters and the way voters make distinctions, right? To an average Ohio citizen, the name of the whatever county Republican or Democratic Party, Central and Executive Committee, they call that the county Republican Party, right? And so I do not, in my mind, know the internal struggles that, you know, if they were properly noticed and the bylaws were followed, then maybe they can do a membership or a leadership change in that party. I don't know any of that. I really feel that a full hearing would allow us to figure some of this out. Because in my mind, there is real question that 3517.20 could have been violated. I believe there's probable cause. So.
Other comments? Director?
Nothing additional to me, no.
Is there a motion from members of the commission?
Interested to hear some.
Doesn't seem to be any feedback at this point.
I'll move we proceed to a formal hearing.
Is there a second?
Madam Chair, I'll second that motion.
All in favor? We'll do individual votes.
Will you go ahead and call the roll?
Yeah,
Okay.
call the roll.
Mr. Lyle,
No.
Ms. Davis,
Yes.
Mr. Kirscher,
No.
Ms. Hagan,
Nay.
Mr. Caraway,
Yes.
Mr. Knight,
Yes.
Chair Tavares.
No.
That motion fails 3-4.
Okay, so we have a failed motion. Is there another motion?
I'll move the executive director's recommendation to dismiss the case.
Seconded.
It's been moved and properly second. All in favor say aye, or we'll do a voice vote as well.
Yes, I.
Yes.
On the vote, so. Ms. Davis,
Yes.
Mr. Caraway,
Nay.
Mr. Knight,
Nay.
Ms. Hagan,
Aye.
Mr. Kirschner,
Aye.
Mr. Weil,
Aye.
Ms. Tavares.
Yes.
That motion passes 5-2.
Thank you very much.
Thank you, Commissioner.
Thank you for the presentations. Next, we're going to move on to the hearing, number 7. Allen versus Department of Law, and that's case number 2023 or 2023 G-004. Time and our folks to leave out.
That race. I think that's our still the stadium.
Madam Chair, members of
Yes.
the commission. This is a case where the complainant asserts that the respondents raised funds and acted like a political action committee without finding the required designation of treasurer. Commission set that matter for a hearing. The addition of complaint, the respondents have used a portion of the funds raised through a funding account for personal reasons, to make sure where that goes. There are a variety of responses that the committee had received. The commission decided to set this matter for a full hearing. So we are here today for a full hearing. Mr. Allen is the complainant, and looking at the response. Mr. Richard Carr is here as counsel on behalf of all the respondents. Mr. Carr, neither of the respondents nor Mr. Carr were here when the commission heard this matter in preliminary review. And so we're presumably ready to go. It is Mr. Allen's responsibility to provide a case to the commission.
Thank you.
You need to be sworn. You need to be sworn. Yes.
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Go ahead, Mr. Allen.
Thank you. When I was here last time for the preliminary hearing, after I left, I had some discussions with people that are attorneys, because obviously I am not. And I'm not going to be nearly as eloquent, I'm sure, as Mr. Carr at arguing this, etc. But I have in front of me here the Ohio Campaign Finance Handbook that is given out by the Secretary of State's office. In that, in Chapter 7, the first thing it defines is a political action committee. And it says it is a combination of 2 or more persons, the primary or major purpose of which is to support or oppose any candidate, political party, or issue, or to influence the result of any election through express advocacy. Subsequent to that, we flip to Chapter 9, which is called ballot issue committees. A ballot issue committee, according to the handbook, is sometimes called a ballot issue PAC, is a political action committee that is organized to support or oppose a proposed or certified ballot issue or question. Ballot issues include constitutional amendments, proposed laws, liquor options, initiatives, referendums, and charter amendments. For a local issue, a ballot issue committee may be created to support or oppose the issue at any time before or after certification of the issue on the ballot. The ballot issue committee must file a designation of treasurer before receiving any contributions or making any expenditures.
And evidence to that today, I brought the referendums that were circulated by this organization that were submitted to our city administrator and later to the Lucas County Board of Education, or Lucas County Board of Election. So, which had been asked from me previously. The complaint is very straightforward. And I mean, the evidence is here that they absolutely formed in order to circulate a referendum against an ordinance that had already passed within our city. In early 2022, a developer came to the city and wanted to build an amphitheater. A lot of citizens in the city, I'd say 50-50 in the city, are divided over what this issue was going to be. It went through the proper channels in the city. The city council voted. They passed the ordinance. At that point, their organization, this Not in My Backyard or Waterville Citizens Against the Amphitheater, or whatever you want to call it at that point in time, began circulating these petitions to take this issue and place it on the ballot. That is clearly, according to the handbook, a qualifying factor for them to become a political action committee. At the same time, they began raising funds through their Facebook group, through other things that are through the social media platforms and various things that they did within the community. To date, what we can tell before they took down the GoFundMe page that they had, we estimate that they have raised somewhere around $20,000. So not just a couple of $100 to have an influence on placing this issue on the ballot. Let's see. Bear with me. Permitted use of funds in this, according to 3517.01C6, a ballot issue committee may use its contributions only in ways that match the definition of expenditure as defined by 3517.01C6, or to refund excess or illegal contributions. A ballot issue committee may spend money in a manner intended to influence an election or to make a charitable contribution. Those are the only two things that it states. Subsequent to that, it says RC 3517.08G, no person may convert for personal or business use anything of value from a ballot issue committee's funds. The vast majority of the $20,000 that the organization began to raise was then given to Mr. Plowman, who had filed a private individual lawsuit against the city of Waterville. That lawsuit was against this amphitheater as well, and it certainly supported their issue of stopping the amphitheater from being built. But as a political action committee at that point in time, that's not a permissible use of the funds. It doesn't list that in here. It doesn't say anything about them being able to give this to a person who has filed a separate lawsuit. The lawsuit doesn't say Waterville Citizens Against the Amphitheater versus the city of Waterville. It is 8 specific people that are our husband and wife, 4 specific families in our community that filed this lawsuit, and it is a private lawsuit. I think the last point that I would like to make before questions is just, after I left here last time, I know Mr. Richter, you and I had a lot of back and forth about whether or not this should move ahead. And after I left, I made some phone calls, talked to some folks, and I actually ended up talking to some people at the Secretary of State's office. And one of them happened to have been watching this on the camera that day. They were watching remotely. And they stated to me very clearly in the very beginning of this, they felt Mr. Richter was correct at that point in time. But after listening to my argument, they said that no, this group was, in their estimation, a political action committee that should have registered when they formed, and they should have filed a designation of treasurer with the Lucas County Board of Elections as a local ballot pack. This is something that to date still has not happened. So. You know what, it happened 2 days after I was here last time, and I do not remember his name. I had reached out to them for, to say, okay, am I right or wrong? Because there was a lot of this debate about this previously. What constitutes a political action committee? When did they form? How does it work? And to be fair to the people sitting behind me, many of whom have never been involved in politics before this issue came up, it is confusing. It is very confusing. But when you get into the handbook, all you have to do is pull out this handbook, which is all reading from the day, and it clearly states a political action is 2 or more persons that form, et cetera, as I said before. And then when you get to the issue of whether or not what a ballot committee is, it is something that an entity that circulates a referendum to place that issue on the ballot, which is exactly what this organization did after it formed. There's a lot of discussion about, did they donate to a candidate? It doesn't matter whether they donated to a candidate or not. That's not the argument. The argument was they can't convert the money that they raised to a private lawsuit, even if that lawsuit supports their ultimate goal of stopping this amphitheater. Yes, there were 2. Well, no, they circulated 2 different referendums.
Okay.
One was to place the issue of the ordinance 1022 on the ballot, which was the city council passing or giving the conditional use permit for the entity to build the amphitheater. And the other one was 423, which was a referendum that they circulated to try and stop the extension of a road that would have allowed for the building of the amphitheater. So not once, but twice, they engaged in the exact same activity, which is circulating a referendum as an organization to try and put something on the ballot so that the citizens could vote on it. Both of those failed, but
Neither one of them made it.
no, neither one did. But as it clearly states, a ballot local at any time before or after certification of the issue to the ballot, they are still qualified as a ballot issue committee. It doesn't say it has to make it on the ballot in order for them to become that committee. It says right here in the handbook. And that's the guidance that's given to the general public in the state. The majority of the people sitting behind me right now. Yeah, I mean, a lot of Shannon Bosselman, Wayne Wagner, Tim Plowman, the people, that are gathered today that are part of this organization that were ostensibly the leaders of the organization, but they circulated the referendums. I mean, Shannon Bosselman was the person that submitted it to the city at the time, and she's here today as well.
And do you know how they gathered the signatures?
Door to door. And they held, they had locations that they would put out through their Facebook group, through their organization to say, come to the clock tower today and sign our petitions for referendum to place this on the ballot.
Remember with surprisingly good detail from a year ago, because I think it's been about a year ago. Normally my brain's a little fuzzy. The circumstances of this particular, on the preliminary review, I was, leaning towards not advancing it to a full hearing with my vote. And then Mr. Plowman produced some documents that had photos, if I am remembering correctly, of some very clear advocacy, some expressed advocacy. And that I know, at least for me, made me want to, see more. I cannot find those documents. Do you remember when you passed out?
Yeah, the yard signs and the other things that they had created that were put out throughout community.
And I seem to recall that you put a sticker on them. You put an exhibit sticker on.
Should be in file doc.
I apologize, I don't. No, that's okay. Do any of my colleagues remember that? Okay.
I do.
I would just like to be able to have the benefit of seeing those again, so.
You did get full, I don't think.
Yeah.
Instead of four.
It's, I mean, I know I didn't pull it before I came up. I probably should have, but I didn't.
I corrected all these things. I didn't mean to get us in the low here, but,
No, I may have it. Let's see.
I could not find them
You're welcome to look through this. Okay.
on any of the documents that were sent to us by Mr. Winter. Not saying they're not there.
That's not it. That's 2404.
I thought that was.
No, this is 2304.
I apologize, I grabbed the wrong
Oh,
part.
they go down and grab.
Do you want me to go grab it real quick?
Please.
Yes. That's it, Madam Chair. Yeah, Madam Chair.
Yes.
Acceptable to take a.
If-
People.
If the other commissioners want to take a little recess, while he gets the,
Or let's get the file.
Yeah.
Yeah.
okay. Okay.
Okay, thank you, Madam Chairman. Good morning. My name is Richard Carver. I am an attorney for the respondents named in the complaint. Having had the opportunity to review the complaint, to listen to the testimony that was given under oath at the prior hearing, and the questions that were asked by members of this commission, all of the respondents are present today. They are prepared to give testimony. They are prepared to answer questions. They are prepared to authenticate physical evidence in this case. The genesis of this, as you may remember, was a application for a conditional use permit for an outdoor amphitheater in the city of Waterville, Ohio. When that was filed, the neighbors, the situs of this is directly adjacent to a residential subdivision. So what happened is neighbors started talking with each other and becoming concerned about what was being built basically in their backyard because of the sound levels, the noise, the traffic. It's a one-way street, excuse me, not a one-way street, but it's one street. There's not two different exits and entrances. So they had some concerns and they began speaking with each other and suggested they go to council meetings to learn what's going on. When that happened, there were so many residents that attended the meetings that Waterville did not even have a facility large enough to accommodate them. And there was overflows. So in response to that, two individuals rather, who are neither residents of the subdivision nor respondents in this complaint today, established a Facebook page. The Facebook page is not in my backyard. That's all it is, it's a Facebook page. There's no organization called Not in My Backyard. The testimony that was given at the last hearing by the complainant was it was established by respondent Lisa Weber. That testimony was not truthful. It was established by two women, Mrs. Lisa Weber, who's present today, Mrs. Shannon Bosselman, who's present today, and Ms. Terry Masucci. Ms. Bosselman is not a respondent in the case. She's not a resident of the subdivision. She's the one that set up the Facebook. And her testimony is that she created the Facebook solely to keep residents informed of what was going on in their neighborhood and in their city. Contrary to the testimony under oath, given at the last hearing, there was a GoFundMe account set up, but it was not set up before the Facebook page. It was set up after the Facebook page. The GoFundMe account was established by Mrs. Lisa Weber on her own, not with any other group of people involved in it. She set up a fund to raise money for legal defense. What she'll testify to is she's at a meeting. She's has a lot of people who are neighbors there. She does not reside in the subdivision. And they were upset because this was going to impact their subdivision. So they said, we're going to get an attorney. The applicants for this permit there was more than one applicant, they had attorneys. For whatever reason, the city of Waterville decided to conduct this as a judicial hearing, quasi-judicial hearing, with the mayor acting as the judge as far as taking testimony. There was depositions taken by the applicants beforehand. And so the residents, some of them got together and got an attorney to represent them in that case. Ms. Weber raised money solely for legal fees. It has been submitted already to the commission. I also have them with me today. Every bank statement, every check was written solely to the law firm that represented the individuals who filed that lawsuit. Not all of them are respondents to this case. A few of them were in the lawsuit, but the rest of these respondents were not. Every penny that was received was used to pay legal fees for a matter that has nothing whatsoever to do with an election. There was no money spent, collected, received for any referendum. The testimony was just given, or statements that were just made, was that this committee of supposed organization called Not My Backyard was created in August of 2022, and it was formed to circulate a referendum. There's no possible way that can be truthful. There was nothing to have a referendum on in August of 2022. You cannot have a referendum until the city council votes on something, some ordinance, then you can have a referendum. There was never any discussion of a referendum in August of 2022. The city council did not take any action on this until after Thanksgiving, the last week of November of 2022. And so that it was not set up for purposes of a referendum. Again, Ms. Weber is here today. She will testify that all funds at all times were deposited into an account in only her name. She was the only person who could write checks from that account. She did not need approval of anyone else to write those checks, and she issued them all to pay legal fees, which is how she raised the money. Ms. Weber established the GoFundMe account on her own. She had another individual named Tyler Hout, who did the, for lack of better words, the mechanically installating, and it was on multiple Facebook sites, not just the Not In My Backyard Facebook site. No money was ever solicited or expended or received for any candidate, any political party, any ballot issue. There's no requirement under Ohio law that you have to designate a treasurer or file a campaign statement until you start raising money for a candidate or a ballot issue or a campaign or those natures. None of this. This was simply raised, as is demonstrated clearly on the bank account statements and the checks, for legal fees, which is perfectly allowable for any residential neighbors to do. The testimony under oath given at the last meeting, which raised some questions, I believe, was that the meetings were closed meetings. And elected officials were not allowed to attend the meetings. Again, the evidence will show today that in fact, 5 of the 7 elected officials in the city of Waterville not only attended those meetings, but some of them spoke at those meetings. The meetings were not closed. There was no group. This was just residents who came together objecting to the conditional use permit. Some of them filed a lawsuit, not part of any group. They filed a lawsuit. Other people did a referendum. The two are directly opposite each other. They cannot possibly be working together on it, because an administrative ordinance is subject only to an appeal in the judicial system. You cannot do a referendum on an administrative appeal. So a legislation passed as an administrative act is only subject to court review. The referendum is if it was legislative. And so there was the different group that circulated petitions for a referendum. It was not the same people. It's not the response. Some of the responses had absolutely nothing to do with either the lawsuit, had nothing whatsoever to do with circulating petitions. I think one respondent here today
was on the circulation of a petition for one of the referendums, but not the other one. The claim that the money was changed to use for an administrative appeal. Again, the money started being spent in August, I believe, of 2022. There was nothing to have a referendum on until November of 2022. So it was not formed for purposes of a referendum or a ballot issue committee. There was no money ever expended for any of those purposes. The complainant also at that hearing gave you pictures, which he said were prepared by some group. The testimony today will be that no group paid for those signs, that there was 2 individuals, none of whom are respondents here today, who on their own had signs made, and they put the signs up in different spots in Waterville. The other sign was a 4 for 4, which was paid for by one of the candidates, Wayne Wagner, and was listed on his campaign finance statement filed with the Lucas County Board of Elections. No group did these signs. The complainants testified that the group handpicked candidates. There's no evidence that any candidate was handpicked. There's no organization. Not in My Backyard was simply a Facebook page. A different individual did the circulation on the GoFundMe account. Has provided complete record showing that every penny went only to that. What you have to examine, what is the major purpose of the funds collected, the primary purpose? It's not a political action committee. It is to legal defense fund, which is perfectly legal to do. Now, I've made several statements that allegations in this complaint before you and testimony that was given by the complainant at the last hearing were false. And you may wonder why would he give false testimony? I listened to that hearing. On at least 2 occasions, he referenced that he had ran for state senate somewhere. What he didn't tell you is he was a candidate for Waterville City Council at the time he filed this complaint and at the time he appeared before you for the hearing. I direct your attention to the complaint itself. The complaint was received by this commission on April 25th, 2023. 15 days before you even received the complaint, the complainant stood up at a Waterville City Council meeting where he is running as a candidate against 3 of these respondents. And this is what he said. I wanted to update you on the complaint that I filed with the state of Ohio in regards to NIMBY being a political action committee, not a ballot committee, a political action committee. I was contacted today by the folks in Columbus. They told me their staff attorney had reviewed the complaint. They find the complaint has merit and that it is correct, and they are now moving ahead into the hearing phase. There is no possible way that you could have conducted the investigation of this complaint 15 days before you even received it. There's no evidence that it was found to have merit. Everything is being created for purposes of a political weapon during a campaign. It's not a political action committee. It's not a ballot issue committee. It's residents doing what residents do. And that is someone one way, someone another. Each group did something that they were not one. And none of these respondents can be said to be part of any specific group that organized this. Again, if you take a look at the petitions, only 1 respondent is on the referendum petition. Look at the complaints, there's 2 or 3 of the respondents that are on that. Some of them had nothing to do with any of it. And so it's our position that they should be found that there is no probable cause on this and that there is no violation of any of the 3 acts. There's no evidence that money was raised for a political action committee, a candidate, a ballot issue, no money raised for any of that. So therefore, there's no requirement to designate a treasurer, which is one of the charges. No requirement to file a campaign finance report because no money was raised for any of those issues. And no money was given personally to any candidate. The money was paid directly by Mrs. Weber to the law firm. And I'm prepared to answer any questions or present our witnesses.
Questions, I don't know tonight.
I know you mentioned it. Could you remind me exactly what the lawsuit that was being funded by the GoFundMe page, what it was in reference to.
Yes, when they filed the application for the conditional use permit,
The amphitheater.
the amphitheater, yes,
Okay.
the amphitheater. Okay, again, the applicants had attorneys. The city of Waterville advised the public that it was an administrative matter. They went and then obtained an attorney specifically for that reason. That's the only reason they obtained it.
To
The
oppose,
lawsuit,
oppose the application.
yes.
Okay.
But the main reason for it was because if it had to go to court, because they were already taking depositions before they even hired, got into the hearings, depositions were being taken. The lawsuit was an administrative appeal, and there's multiple parts of it, which include the fact that the meeting was posted as a special meeting. The agenda stated it was a special meeting. The meeting was called to order as a special meeting, and the minutes say it was a special meeting. Waterville's a home rule community. Under the home rule community, they set their own rules under their charter. Their charter required they have 5 votes to pass an ordinance at a special meeting. They only had 4 affirmative votes, so it was 4-3. So that's one of the arguments. I'm not the attorney who handled that case. That's completely separate.
Yeah, I just wanted to make sure I understood what the case specifically was involved, and then I have one follow-up.
Yes, sir.
So the law firm that handled that, that case, were they fully funded through the money for the GoFundMe page, or did they have other sources that paid for the fee?
No, the money up to that point came only from the GoFundMe account. There is an appeal presently pending, and they're not using GoFundMe accounts to do that. The people who are parties to that lawsuit are apparently paying that on their own.
Okay, but to that point, the sole financing for that lawsuit came through the GoFundMe.
That's correct.
Which was on the NIMBY website.
Yes.
Facebook.
Based on the NIMBY Facebook, also on several other Facebook pages as well.
Okay, I just want to make sure I understood. Thank you.
Yes.
Any other questions?
Sure. I missed your name, I apologize.
Carr, C-A-R-R.
Okay, Mr. Quick question. So we talk about, the Facebook page and not supporting candidates, really, they were principal focus appears from your been a legal battle. But on February 24th, as part of Mr. Plowman's complaint, Terry, I'm going to just say her first name, Terry. I apologize. I can't pronounce it. Masucci. Okay. So Terry Masucci wrote, meeting to discuss fundraising ideas for our candidates. And that was, I believe, concerning to me during the preliminary review, Plowman, Wagner, Garver, and Harrell. So how, if the group isn't engaged in political activity, how would you explain those 3 lines, a meeting to discuss fundraising?
Yeah, I'll start with this. Ms. Masucci is not a respondent in this case today. When she is referring to it, if you listen to the testimony on multiple occasions, the complainant, Mr. Allen, stated, we are not able to get information. Again, she is speaking for herself. They had meetings of residents. They had meetings of residents. Some of them talked about running candidates. Not one candidate was announced their candidacy until after the decision was made by the Waterville City Council. So they were not, this is not an organization that was meeting. There were residents at these meetings that did not live in the subdivision. There's residents that did not even live in the city. That was, this case got one of the adjoining villages tried to join as a party to that administrative lawsuit. So when she says our, it's people who were against the amphitheater. That's all it means. It's same as Mr. Allen using we, when he was talking about people who generally supported the amphitheater. Our is simply the people who were opposed to the amphitheater. There's not one group doing all this. That's the point. And again, when he testified that these meetings were closed and the elected officials couldn't attend, that's not even truthful.
Mr. Carr, I do apologize. I did say Mr. Plowman. Or
Honestly.
Mr. Allen, I apologize.
Other questions?
Not unless asked.
May I?
Go right ahead.
That's a lot. And again, I'm not an attorney. I'm just a citizen in the same city that these people live in. But I'd like to address a couple of things that he has to say, because basically what they're saying is they have a Facebook group that formed in August of 2022. And on that Facebook group, they absolutely, as you said, they were raising funds for a lawsuit. But on that same thing, that same website, that same Facebook group of 900 or more people, they continued to do things where they talked about, this is where we're going to meet to sign the referendum. This is where we're going to meet. We're going to be at 234 Cherry Lane at such so-and-so's house, or not Cherry Lane, but Harvest Lane, to have you come by and sign our referendum. Mr. Carr would want us to believe that a group is only a group if it decides to be a group. Only if it decides to take that extra step and register themselves as a ballot committee do they actually become a ballot committee. And that is not what that book says. It says that when a group, and this group, they are definitely a group, they are definitely an organized group of citizens within our city. While they may have different functions within it, they all stem from that same "not in my backyard" Facebook group. On that, this is the activity they engage in. They engage in together, talking about and encouraging each other, sign our referendum, give money to the lawsuit. This is the activity they engaged in from that one Facebook group. There may be others extraneous to that, but the argument that they're not a group and they're just a separate group of citizens that just happen to be all in the same place at the same time is, I think, a bit much to believe, especially when they are engaging in clearly engaging in political activity within our community. And I've never said that they donated to a candidate. The argument has always been that they formed a political action committee through this Facebook page. Yes, the Facebook page formed in August of 2022. And that's when they started to inform each other about what's going on. But as they go forward, they continue to take more and more political stances within the community. And they get to the point where they start circulating referendums, circulating recall petitions against two of the sitting councilmen that I have copies of all of that as well. The group was clearly unified in their opposition to something happening in the city, but their entire intent has been political. It is a lot to believe that you can form something and only call it what you want to call it when it suits your needs, and then to come in here today and say it's not any of that.
Madam Chair, could I just respond very briefly to that?
Very brief.
Very briefly, ma'am. You referred to 900 people on a Facebook page. There's only 5 respondents. The person who formed the Facebook page, Lisa Bosselman, is here today. She's not, Shannon Bosselman, I'm sorry. Shannon Bosselman is not even a respondent. She used the Facebook page. There's no evidence presented that there's any respondent to this case, organized, ran, or with any group. He just simply chose one person who raised money for a lawsuit and 4 candidates who were running against him and 3 other candidates. I have exhibits, if the committee wants them, where him and the 3 other candidates ran ads on Facebook. look like advertisements on Facebook for 4 of them. The only reason these 4 are named is they were on the ballot against the complainant. 900 people claims it not in my backyard is a political action group that doesn't even name as respondent the individual that formed the Facebook page.
Thank you.
Madam Chair, Mr. Hughes is looking for the photos. So that was in my mind, a pretty important part for me from my perspective.
Not sure what else it would be. I apologize.
So
I have no recollection of that.
I give me 5 minutes of them, thinking of it myself, that he was looking through, and I guess, I don't want to hold the commission back on, maybe the other commissioners don't have any interest in seeing the photos, so I don't want us to hold up just for me singularly, but, the Facebook post and the signs, Mr. Carr has said that none of the respondents, purchased those signs as part of the group. And so I don't know how we would proceed if we need to them under oath. I maybe think that's necessary. So
Thank you.
that's all I got, Madam Chair.
Mr. Knight?
Question for the executive director. Quasi comment. So let's just take even the pure definition of the PAC, right? Seems the advocacy certainly more than 2 people. But if the commission found that this should have been a PAC, who would be the responsible party? Would it potentially be Ms. Weber who set up the Facebook page? Would it be the person who managed the GoFundMe aspect? I mean, it seems to me that there's nobody listed on the complaint that would have responsibility for said PAC. That's, yes, like, if we determine it was a PAC, I'm not saying it is at this point. Who, I mean, or is a complaint even name a individual who would have been responsible?
It doesn't appear so to me. And I've held off commenting, but first off, there has to be an electoral issue in order for there to be a PAC. With all due respect to Mr. Allen's arguments, until a matter gets on ballot, there is no electoral issue. And you look at what political action nominations are more personal. The primary major purpose is to support or oppose any issue or to influence the result of any election to express advocacy. You have to have something on a ballot first. You have to have an issue in order for there to be a political action committee in a situation such as that. And I don't believe that's been established for you. With all due respect, you can circulate petitions to your heart's content and you can submit them to whomever. And I get into these conversations every now and then where people will reach out to our office, to me, what do I do? And I do my best to help them. I guess I'll put it that way. And oftentimes I will get into the conversation of when you file that designation of treasurer can be problematic. Because if you go through all those efforts and you do get the actual issue on the ballot, and then you establish your PAC and you try to claim contributions and expenditures prior to the filing of the DOT, you're out of time. Alternatively, you have an ability to go ahead and file a DOT, even if you never get on the ballot, you're just self-declaring that you're a political action committee. That's okay too. But if you go through all these efforts, even put the petitions in, and it never gets on the ballot, there isn't any issue on a ballot for which a political action committee has to be created. And so based on what I see here, this group They did some of those things. They never made contribution, the statement that we have from Ms. Weber in the file reflects that, no contribution were ever made. They only paid money to the lawyers. And even that was for the legal challenge, not necessarily for the petitioning process. There isn't an electoral issue here for which a PAC had to be created, or for which there was a responsibility to file a designation of treasurer to create a PAC, in my opinion.
And does it say somewhere else that has to be an issue that's on the ballot? It can't be like general political issue or question?
That's where you get into it determined, it can be determined by how the party wants to go about establishing for themselves. But when you're talking about to influence the result of any election through express advocacy, that's how you get to, it has to be a matter that's on the ballot in order to have it be declared a political action committee. You can still create that in anticipation of it. If you want to do that, then you're just filing DOT. You're saying, I want to be a PAC. You have an ability to do that. But that's that language is there in the statute to influence the result of any election. If you never had an election, you aren't necessarily a PAC. You can be if you want to be, which is one of those great confusing things about, campaign finance law, not only here in the state of Ohio, but probably you don't have it with regard to ballot issues on the federal level. But, if a person tries to get on a ballot, I shouldn't get into FEC language, so I won't. Go ahead.
If I could, Madam.
Yes, please, Mr. Kirsch.
Didn't have the benefit of the preliminary hearing, surely reviewing the materials. So I want to make sure I understand the matter for which Mr. Richter, the petitions were circulated was not ultimately an issue that got on the ballot.
Correct.
And the lack of an issue on the ballot is, from your perspective, dispositive.
Yes.
Such that there wouldn't have been a need for a PAC and thus no violation.
That's certainly my belief as to the circumstances that we have seen presented to us and in the responses that have been provided to the commission as a part of the process so far. Yes. I'll make it more confusing because I'm always going to make it more confusing. Like I said, these folks wanted to go out and establish a PAC before they did any of this. There isn't anything that prevents them from doing it. All you gotta do is file a designation of treasurer.
To take it just one step further,
They don't have to.
then the issue of when and how and where the funds were spent is, from your perspective, not germane to the issue.
It's not a political issue because they were spent for that lawsuit that was out there that was totally separate and distinct.
So we don't get to that decision because, from your perspective, there was no need at the outset to register because the issue didn't.
Never made it
Never made it.
Never made it.
So we don't get this.
Correct.
It's helpful to understand your perspective. Appreciate it.
Mr. Richter, can I ask a question? Just specifically, Mr. Richter, I might be able to resolve the whole thing. I'm not an attorney. I have to stand up, but I think the confusion comes in for the general public when we get to that part in the campaign finance book. This may be fairly me not understanding this clearly.
Please, Madam Chair.
I understand.
If you're gonna ask.
If I could.
But the question is for the local. Oh, go ahead.
I would just note that Mr. Richter is our staff attorney and would encourage the understanding that he's not here to provide legal advice to third parties.
I think the confusion is for where it says in the handbook, local ballot issue committee. For a local ballot issue committee, a ballot issue committee may be created to support or oppose the issue at any time before or after certification of the issue to the ballot. Doesn't say it has to be on the ballot. I think that's where the confusion is according to the handbook that's given out to the general public, it says before certification to the ballot, you can still be a political action committee, a ballot committee.
I just said, yes, you can be, if that's what you choose to be. The comment you included in there is maybe a party, a group could do that. And the other challenge that you're dealing with is in reliance upon the handbook. The handbook is a document provided by the Secretary of State to try to put into common language the statutory provisions that are controlling in any situation. And the statutory provision talks about, again, more persons, we got that, primary or major purpose, we got that, to support or oppose any issue or to influence the result of any election through express advocacy. There is no issue on the ballot. There was no express advocacy for that issue because there was no issue on the ballot. And so therefore, there is not an obligation, there is not a specific obligation for them to be a political action committee. So, I mean, I would say that's, my interpretation of the statute, but that's been the long held interpretation of the statute. Because that particular, actually, the couple of things that have changed in there over the years is just the discussion, the addition of primary or major purpose and through express advocacy. If you go back into the 80s, those terms weren't there. It was two or more persons to support or oppose, et cetera, et cetera. Subsequently, that's the only change, but essentially, this has been the essential basic definition of a PAC as long as I have been aware of it. And so the Secretary of State's office does a good job of putting together a handbook. And it didn't say you had to do it ahead of time, as I indicated. Like you could, I could set up a PAC right now for something that's 10 years down the road. The challenge that we often see it is something gets on the ballot. The group either support or opposing, creates a PAC after the fact, then they try and claim contributions or expenditures that occurred during the process of getting it on the ballot or whatever. Then they're out of time. Then they filed a late designation of treasurer. And so, like I said, I talk regularly with folks and just, I obviously am not their attorney, but in an effort to help them and advise them to say, just be mindful of when you are establishing that PAC, when you're filing the DOT and what you're trying to accomplish. So, at least that's been my long held understanding of the statute and how it applies. And how I've advised this commission since that's the position.
Thank you, Mr. Allen. Any other questions or comments? Yes, Mr. Watt.
Director, so Mr. Carr stated that the monies that were raised were for a legal defense fund. Is that in your mind legit? That can occur?
It's outside of this commission's purview, but there are those kinds of things that can be created. Yes, I would say basically I'm aware of them, but that, those things are not necessarily campaign finance related organizations.
Okay. And then,
they could be, but they're not necessarily obligated to be.
Under Ms. Weber's statement, there's numerous checks. It's very difficult to read because the ones I have are sideways. So do we know if, and maybe there can be testimony to this, do we know if all those funds were in fact used? I mean, best I can ascertain they were, but you have X amount of funds, whatever they are, were they actually used for the attorneys and only the attorneys, or were they used for other?
Yes.
Yes, I'm not sure you received these exhibits that were submitted by Mr.
We did, yeah, they came inside.
I
checks.
I took them and matched the check with the statements, showing that all the funds did. There was a very small amount of money left over at the very end. She donated that to a nature reserve.
Oh, okay. I thought your statement.
That was like
it's gone to
1 or
fire
2%. Not even that, it was just, like $30 or $40, I believe. She could testify what the amount was. But all the rest of it went only to that attorney, that law firm that handled the administrative.
And they fought it in front of the city council and mayor, and then subsequently to common pleas.
And now they're at the Sixth District Court of Appeals.
Oh, so they're still going with
Yeah.
that? Or so is their money still being raised?
No,
Okay. Because the judge, the common pleas judge said that the amphitheater could go forward, what I saw here on
right,
a periodical that I have, right?
yes, that's correct.
Other questions? Yes, Mr. Kirschner.
To the complainant, do you have, not opinion, but do you have any evidence that would disagree with the respondent's position that all those funds were used for legal fees?
No,
Don't have any evidence?
Not with me,
saying
no.
that.
no, not to my knowledge, no, I don't have anything, not with me, no.
Questions, comments, from members of the commission? If not, is there a motion?
I don't think, surgery didn't know.
I don't make recommendations for
You
it.
don't.
Assessment of the evidence presented.
I'll make a motion to dismiss the complaint.
I would second that.
Been moved and properly second. Are there, all in favor, say aye.
Aye.
Opposed? That. 570. Vote.
Thank you.
Not sorry. Okay.
I just make one quick comment, Mr. Richter, and I'm very, very short.
20 minutes ago.
Others, the Lucas County Board of Elections will not even take finance in front of referendum, it's part of that.
I'm sorry, they won't.
They won't even take, if you want to, if it's not on the ballot, they don't even take financial statements, they don't even know what it is, yeah. So,
Well, that's different than it is in other counties, but I can't say I'm surprised.
88 counties, 88 different ways.
Exactly.
thank you all.
Thank you.
Thank you. Thank you. Ms. Smith, I know we have the next hearing on May the 16th. But is there any discussion from the commission members of an update from the executive director? I believe at our last meeting, we were going to have an update from the executive director on the plan.
Yes, if I could, Madam Chair, I think that the primary focus of the executive session last time was the employment-related issue concerning the transition as reflected in the minutes. I think what we were going to do is to get the committee to evaluate and address that moving forward. Mr. Ritter, that would be appropriate from your perspective.
I don't have, yeah, that certainly makes sense to me, as we proceed forward through this.
I think we have to get the job posted and evaluated and make sure that we have a transition plan in place. So that we have something to execute on over the next couple of years.
Yeah, and that makes sense. And it's a matter too of choosing, who's going to be on the committee.
Right.
And certainly I would encourage, I guess, the committee to be 3 persons or less, only because if you've got 4, then you've got a quorum requirement that would obligate public meetings. I don't think we want to go through.
Well, that's what I want to make sure we have some good guidance on what we do as a committee as opposed to.
Yeah.
But again,
Because at one point, I'm sorry, I was just going to say, going way back at one point in the early days of the commission, you had kind of an advisory opinion subcommittee that was comprised of 3 persons, the DNR, and I think Mr. Webster was originally involved. And as I was writing advisory opinions, then I would circulate to the 3 of them. They would offer come in and come back and go forward. Subsequently, that was just disbanded, but we never went beyond that. So I would say, if there are 3 persons that have an interest in serving there,
Yeah.
Yeah, let me just
I'm sorry, go ahead.
make a point before we go any further.
Yeah.
I think the committee needs to be representative of each of the parties and the independent. Mr. Knight,
Yeah.
I'm sorry, but I think you should be one of the three. And then to make sure that we stay under the
Right.
four.
And just so that I wanted to be crystal clear, particularly in this public forum, so that the exclusive issue to address would be the transition plan of the executive director. And we would have a committee of this group. Help me understand, Mr. Richter, if you would, what you think would be appropriate for that committee.
I think just trying to assess, what the overall commission's desire is as it relates to, I guess I'd say a subsequent replacement.
But also as to the makeup of that committee. So if we would have 3 persons, we could do that offline, so to speak, and address those issues.
Yeah, I believe so. I believe so.
And then I do believe that 3-person committee should outline a schedule of reporting back to the full committee on where they are with respect to the succession plan, so to speak, and process that we're going to kind of recommend back to the full commission,
Yes.
so that we stay on track and that we have a timeline.
And I would propose to that end, maybe monthly updates, just so, being fully transparent about what's being discussed and that everybody's up to speed. And, so it's reasonable.
What is the
Anybody
time,
else?
I'm sorry,
Go ahead.
what is the timeline for formulating the committee? When are we talking about doing that? Like
You said, yeah.
Okay.
I, Madam Chair, would like, I would like some more time. I think, I was gonna ask Mr. Richter if it was proper for the 3 Republican members and the 3 Democratic members to talk amongst themselves to decide, which one of us should represent, and then, the other party, I mean, Commissioner Knight. Listen, your meeting will be really short. So.
I got a lot to say to mine. It's gonna take a while.
If you bring a couple of mirrors, you can talk to a whole group of attorneys.
Just make sure there's not 4 mirrors.
So, and Mr. Kirshner, I'm not trying to punt this off. I didn't necessarily, because of the amount of, was on the docket today, I didn't necessarily think we were even gonna have time to talk about it.
Right.
But I would like some time for the 3 Rs and the 3 Ds to talk about who our designee and then make sure that the committee, though its work I believe will be important, that we're not losing the overall commission's will through this process, through a collective voice. And so that would be my only request, is that we have until May.
Well, May 16th is the
May
next meeting, and
come up
so
with.
tell you what, maybe I'll reach out to everybody by next Thursday. Just to see if there's an update out there that each of the respective parties are willing to commit to.
Yeah, because I don't think it's gonna take
No.
us a long time to come up with them. I'd rather give you guys the time that you need. If you want to do it today.
Oh, it's 12:50.
Yeah.
Yeah, because it's got time issues.
Yeah.
Mr. Caraway has time issues. I've got a time issue as well.
It would take 5 minutes, I'm sure, but.
And there's one, if we're done with that, there's one other issue that I raised briefly in an email as it relates to the office, not office space, the meeting space where I'm talking about going to, which is scheduling, which means going out, beyond 6 months. And as I'll give the brief explanation. When we were in our own space and had our own meeting room, all I had to do was reach out in October or November to say, okay, what are we doing for next year? And it worked out because we never had a problem getting meeting space, et cetera. Well, it's become a little bit more challenging here, but considering the meeting space, which we're going to enter into and the potential for other groups wanting to use it, I'm thinking that we need to start scheduling out. It's going on there. I talked briefly with that with Mr. Caraway.
Where's that?
It's in the basement level of B1. It was a restaurant.
Yeah.
Yeah. It was a restaurant at one point, going way back. it's been bright, because they turned it into a conference, a meeting room. And there are, and it's, I guess I'd say technologically modern and up to date. And so we'll be able to link into Teams and have it broadcast across the state and have people come in and have a back and forth. And Chris and I are thinking that it could become very popular. And so right now we've got it, except for one meeting in the second half of this year. All of our meetings are scheduled to take place in that meeting room. And so I'm going to suggest that everybody, either get back to me in short order if they have any conflicts beginning in January of next year. That's one into the.
Do you have some proposed dates though for?
No, my normal process is to say, if you've got a conflict, let me know and then I'll schedule around it.
But then you gave us nothing.
Yeah.
Okay, I'm sorry.
Oh, sorry, just like a kid sister and me and like small business owner says, why not schedule like the consecutive 2 Thursdays in the month into the following year? And then if we have to cancel or accommodate, maybe we have until the end of the year to submit. Any conflicts, and then we can adjust. Is there any harm or foul in grabbing those dates?
Not necessarily, not necessarily.
It's gonna be impossible to find dates that are gonna always be good. So if we just go on this every other Thursday cadence, that makes a lot of sense.
But then cancel.
I'll probably only have one meeting in, well, like the summer usually is what.
Right.
only did one?
Yeah.
It depends on when Christmas is. If
Okay.
it's early and mid, then I'll show two.
It's usually on my
Got two
birthday and
this year.
anniversary.
Yeah, we try to get up and just do
At least one or
convenient
two.
dates.
That's a given, even if not Thursday, her birthday.
All right. So I will send out a tentative schedule here shortly, looking from January through June of next year. And if anybody knows that, I mean, I know it's far enough out in advance, you may not have any nobody have any issues at this point. But if you know of something that's gonna keep you from doing on one particular day and there's something, let me know. So we'll declare it official until everybody comes back and gets back in touch.
So give us a deadline to get back to see.
After I send it out,
Yeah.
probably about a
Every
week.
time.
Okay.
Or should we plan like every other just one
to the end of the year for 2025.
Oh, to the end of the year? Yeah, we do. I don't know why not.
Yeah.
Look at
Okay.
Yeah,
Okay.
that makes sense.
It's just that was based on what
We're gonna send out, set up every other Thursday dates and then we're gonna verify against it. That's the plan.
Yes,
Yes.
yes.
Yeah. And I'll probably only have one in June, July, and August, because that's historically what
Love
we've done. But other than that,
Is it typically the second and fourth?
no, not really. I kind of float around a little bit.
Okay.
Like I've always kind of floated around. Some of it's because maybe I had something scheduled, I know that's been the case, or Mr. Lyle may have, a trip planned somewhere, and I've always worked around those dates. And so that's why it's not been historically just, every 2 weeks.
And the commissioner Hicks may get down there and not like it. I don't think that's the case.
Picture.
Well, I think the
Yeah.
pictures you sent.
The problem is my photography was not all telling. I didn't take one of the other part of the room, that there's
I
like,
did notice
there's like
that.
100 chairs. I mean, so.
There's that.
Yeah, I think it's very good.
Deal for me, and I believe it's better than the space.
Well, and the point that I made to Mr. Richter and Mr. Hughes was, it will not require capital expense on any technology.
Yeah.
Because it's already there. It's literally plug and play.
Very nice.
We'll take, and we'll take, Chris will take the computer down and be able to tap into Teams
Yeah.
down there. So I can't see it on Teams screens.
We haven't adjourned yet, so can we have some order?
Now,
Sorry.
Madam Chair, I do want to point out, if I may, that, and this is something for all of us to think about, you can access the room without going through security.
Right.
Okay, that is, I would think, the only downfall. I don't think it becomes wild, wild west here too often, but you can access the room when you walk into the right, go right down the staircase, you're at the room.
Right.
So you have not been screened.
Or if you
Or
come
when
from
you
the
come into
garage.
the garage. Yeah,
Correct.
when you come into the garage.
So something I think
Go
that
off to the right.
all of us need to keep in mind.
Your concern is that other people have not been screened?
Well, we've had rowdy folks who have been under a lot of pressure and stress, in which case we said, they go through security. So this would pose a different environment. So may I recommend, do we have access to the troopers? If and when we know something is high level of intensity, we may request their presence.
I have reached out. Well, if I've gotten an idea that there may be something, and that's a very broad-based statement, but I think it's appropriate. I've reached out to the state troopers and they'll send a plainclothes person over to sit in, so.
Well, maybe it's just a consistent basis if it's an extended hearing, almost always, or if there's a really
Yeah.
concerning individual case. I mean, the one that we saw that I thought was probably most alarming or gave me the most sense of pause. I had my daughter in tow and that person kind of locked in on the baby and almost seemed to reverse course in the level of anger. And so it's a good idea to know what kind of pressures people are under.
Well, then, Madam Chair, if I could, go ahead, please.
No.
Mr. Kershaw.
So are we saying that the folks that come up here have been screened by security and the folks at the new spot would not have been secured?
Correct.
That's a problem, from my perspective.
Yeah, well, so
It's not the expected ones, potentially, that could be the issue. It could be the unexpected.
so that is the only, go ahead, I'm sorry, then I'll.
But no, so then my question was, is there any way that as a standard rule of practice, the troopers show up and are present for every meeting? And not that they have to sit there,
Right.
but, I think as a walkthrough, because the reality is we don't know, I mean, people can be screened, but at the same
That's just it too, yeah.
projecting that because the case is a certain way, that these people could behave this way. I get that, but there's the unexpected, to your point, that you never know.
I'm just surprised that there isn't a checkpoint there.
Yeah, we've got some time until it occurs. I can reach out. Building management and.
And don't forget, we are 60 feet from a uniformed officer.
Right.
Not a trooper, a state police officer who works for patrol.
Right.
But, we could also, request that they be routed a certain way. Because if you walk in the building and you go lefter, you have to be screened and then you could take the staircase down that way. So you would not be permitted to go right or through the garage. So.
I mean, that's a good point. If to attend the meeting, you have to have your, screen badge.
Yeah.
That would be a way to separate.
The best I can say at this point, I'll raise that issue with building management. Also.
I lost you.
So, they can still come in through the garage, though. I guess that's just something like, yeah, because all of us that don't have badges come through the garage. And if it's somebody who doesn't have a badge, they could just go straight into the room.
Whether there's a separation area or turnstiles from the garage, I forgot it. Remember, the general public can't get through the turnstile from the garage. You can because you got a card.
No, but if they're already in the garage and it's not full, they could come straight in to this building.
Oh, will that just open up automatically without the card?
Yeah.
Okay, I always place my card.
No.
Thinking you was doing something.
Yeah, but you've got to swipe.
You're gonna swipe.
To go, yes, to the left, but to come straight through those glass doors,
Oh,
you
yeah.
go straight into the hearing room.
Last.
And you don't have to have
glass door.
Yeah, you don't have a,
Maybe my placement on the turnstile is off. Is it not up that far?
You know why that's it?
Because it's right across from the gate.
Right, it's just off to the left. You go in.
Are the turnstiles down a little further?
Yeah.
So you could access.
yeah.
the hearing room.
You can access the meeting.
Okay, I got you. So anyway, that is the only downside to the room that I've seen. I want to make sure I brought it up.
Well, thank you.
If,
And it should be something that I think, building management takes into consideration.
Yeah.
They may want to move the.
right,
Yeah, thank you.
right.
Anybody else have any comments before we have a motion?
I just had one quick, I think everybody probably has seen it, but just a reminder, we have our Ohio ethics reports are due May 15th.
Yeah. Bring up.
If you didn't receive any, you probably need copies to read. For the new one.
The cool thing is that carry-in feature where you can carry over.
Was my statements for going to say, I think, was she on the list that you sent?
I'll tell you in just a second.
I thought I did, but.
Well, I know you.
Decided to do for 2022, right?
Well, right,
Technically.
right, which means you may not have done it for 43 because you were expanding his changes.
What's that?
And that influences the students. So you probably
But it carries over, so anything that's changed, we can take it off. Right. But everything that may still remain the same as far as expenditures and folks that, receive dollars from.
So
I mean, that's a good part of it.
when I pulled up the liaison dashboard, you are listed as having already filed on January 22. So your state.
I thought so.
January 22.
After you were appointed,
Or no, January 22 of 24. I'm sorry.
Okay.
ethics.
Okay, you're saying the date.
Yes, my apologies. Yeah, January 22nd.
Yeah, the ethics financial.
Same, it's have not done the family.
Okay.
Yeah, all those are the same form. I mean, FBS is, there isn't a,
Right.
yeah, it's one.
Yeah.
Right? Am I missing something?
No, that's just an ethics.
All right. Kind of scared me. I thought I was supposed to be filing too.
No.
Okay.
I haven't filed mine. I got
Well, the cool thing is all my stuff carried over from. Thank you.
You're quite welcome. Do
Yeah, I couldn't resist.
You were thinking this one?
You're welcome to tell me.
Any- Motion?
Motion. I was gonna say dismiss, I'm sorry, to adjourn the meeting, today's,
Yep.
commission.
Thank you very much. Is there a second? All in favor?
Aye.
Opposed?
It is.
Thank you all very much.
Yeah, I'm cool.
You want to do a phone?
Yeah. Well,
Well,
I mean, I'm not.
I've got.
I'm sorry.
No, it's all right. Not, it's not even free of cost.
Oh, I can always. Hey, Carl, I gotta run to the. Carl, I gotta run to. Carl, I gotta run to the restroom. I'll be back. I'll follow you. Okay.
So, Mr. White, you have a minute to talk about where we
Yeah.
really should.
Yeah, I think we do.